Mr. President, you were just coming off of one of the most consequential weeks anybody has ever seen, from striking Iran to going to NATO, to announcing 2 deals, and then this Supreme Court victory. Have you been able to digest what has occurred in the last 7 days?
Not really. It was a pretty wild period of time. And I really think in 6 months, we've taken the country and turned it around. I was told by the King of Saudi Arabia, by the leader of Qatar and the leader of UAE, when we went over there, we brought back $5.1 trillion investment into the United States. They said, you know, you're presiding now over the hottest country in the world. And a year ago, we thought your country was dead. It could never come back. It was so incompetently run by a very bad president. And I said, you're right, this country is hot. And that was a couple of months ago. You know, now we're talking about what we've done recently. So the country is really going. The numbers are great. I watch you in the mornings and you're giving those numbers and they're really good. No inflation. We have a bad Fed chairman, but other than that, we have, you know, great. It doesn't even matter. The numbers are so good. It doesn't matter that he keeps the rates artificially high. But it's been an amazing period of time.
When you went to the Middle East and you strengthened those relationships with all of those countries you just mentioned, did you have an idea that you would have to do something with regard to Iran? Because you teased it a little. You said, look, they've got to come to the table and talk. Something's going to happen.
Well, it was getting a little bit hot, and we knew they had a lot of sites, probably 3 plus the 1. But they had 3 main sites, and we knew they're going to have to either
What
give
is
them
good,
up.
everybody coming
And I thought
in.
we could do it.
We're going to get some updates today.
And we just about had it done. And then they said, we want enrichment. Enrichment doesn't mean like air conditioning, and it doesn't mean to jack up your car. Enrichment is a bad word. And I said, you got so much oil, what do you need that for? And they said, well, we need it. And I wouldn't let that happen. I think people wouldn't have understood it if I allowed that to happen. So we had a 60-day talk, and that delayed them a lot. And then we said, let's go at it. And it just worked out. And we wanted to work out also for Iran. They were beaten up, and so was Israel, in all fairness. They were both very tight. We call it the 12-day war. That was an intensive war. But the thing that I wanted to do, and I've said it on your show, if you look back 30 years ago or 25 years, we've been doing your show a long time, and nobody like you. But you look back at the early interviews, I would say Iran cannot have a nuclear weapon. They've wanted this for years, and they were weeks away from getting it. And those pilots went in there with those beautiful planes and the most sophisticated bombs anywhere in the world. Think of it, they can go 30 stories deep into granite. Who would think that's even possible? And they did obliterate it, it turned out. Then we had to suffer the fake news, where the fake news in CNN and the New York Times was saying, well, maybe it wasn't as good as Trump said. Maybe it wasn't totally obliterated, but it was destroyed, but not just horrible. And I could see it happening. And they tried to build that into a story. And then it turned out, no, it was obliterated like nobody's ever seen before. And that meant the end to their nuclear ambitions, at least for a period of time. And, you know, a lot of people have said, well, do you think they're going to start again? I said, the last thing they want to do right now is think about nuclear. They have to put themselves back into condition and shape.
You tweeted, the Democrats leaked intelligence.
They should be prosecuted.
Who specifically? Do we know who did it? Will you be able to find out?
They can find out. If they wanted, they could find out easily. You know, you go up and tell the reporter, national security, who gave it. You have to do that. And I suspect we'll be doing things like that.
Well, those pilots were so courageous, and, you know, you want to honor them. Are you going to do something for them?
Yes, they're going to come to the White House. But what you said is right. These people flew 36 hours in a small space, a big plane, but a small space that was mostly occupied by bombs. And they flew so brilliantly. And they hit a target the size of this circle. A little target, they say, half the size of a refrigerator door, from 50,000 feet up in the air, going at a rapid speed, because they're going very fast when they're over a pretty rough territory. And they hit it every single time. And then they knocked out 2 other sites aside from that.
Do you think that the Iran regime hid some of the enriched uranium before the strikes?
No, you mean did they take it out of the deep one? No.
Because you were pretty clear you can't have a weapon. You're going to have to come to the talk. Something's going to happen.
I don't think they did. No, I think, first of all, it's very hard to do. It's very dangerous to do. It's very heavy, very, very heavy. It's a very hard thing to do. Plus, we didn't give them much notice because they didn't know we were coming until just, then. And nobody thought we'd go after that site because everybody said that site is impenetrable. You can't, you're not going to be. This way they did. It's at the bottom of a mountain. And it's granite. Granite's the hardest stone, and it's granite. So, no, they didn't. But I do believe they had people there because you had cars. They were saying cars. And those were masons. Those were people working with concrete. They were trying to seal up the entrance to where the bomb would most likely go in. And they did that. They were working on that. And the bomb went through it like it was butter, like it was absolute butter.
Because I saw reports that there were 400 kilograms, 800 pounds that they moved. But I wonder if it's traceable. I mean, if they were to have moved,
they didn't move anything.
They didn't move anything.
You know what? They moved themselves. They were all trying to live. They didn't move anything. They didn't think it was going to be actually doable, what we did. And what we did was amazing. And we went, there were energy commissions that went there now. No, it's just thousands of tons of rock in that room right now. That room, the whole place was just destroyed. And the other 2 also. Now, Israel was able to do damage, but we did the final damage. And we have the greatest submarines in the world. We launched 30 rockets from submarines. Every single one of them hit their target.
How will you know if he tries to start things up again? Because Iran just said that they are halting.
That's a good point, Chad. Let me know. What do you guys think? Do you think they still have nuclear capabilities, or do you think we actually got rid of everything?
Cooperation with the UN nuclear watchdog?
The last thing they're going to be doing right now, for a period of time at least, is nuclear. They've had it. They've been trying it for 25 years. The last thing they're going to do is nuclear. We had to hit them, though. They were close to getting a nuclear bomb, absolutely.
Yeah. I mean, and look, I've heard from people inside Iran that the regime in Iran has executed more Iranian civilians in the past 48 hours than the number of Iranians who died in the 12-day war. So, I mean, you've got a regime that's been building ballistic missiles, building or trying to build a nuclear weapon. Why should we think that they're actually going to give up on this?
Well, they might not give up, but they're going to give up on it while they're exhausted. They are exhausted. They took hits like nobody's ever taken. And frankly, Israel is tied. They wanted to, it was the perfect time. We went in, we destroyed their nuclear capability, and we stopped. It was a beautiful thing. And they couldn't have gone on much further. And Israel was that was a very intense 12 days, very, very intense.
Has any other country suggested to you recently, as a result of this, that they want to join the Abraham Accords?
Yes. So we have some really great countries in there right now, and I think we're going to start loading them up because Iran was the primary problem. I actually thought Iran would. I actually thought we had a period of time where I thought Iran would join the Abraham Accords along with everybody else. And frankly, they would have been better off than where they are right now.
And what about the Abraham Accords? Would Syria enter?
Well, I don't know. But, I did take off the sanctions at the request of some of the other countries in the area that are friends of ours. I took off the sanctions on Syria to give them a chance at, the sanctions are biting. They're very strong. And we have sanctions on Iran, too. And, you take them off when I sort of gave the expression today, you get more sometimes with honey than you do with vinegar.
But you waived the sanctions on the oil with regard to China. So you're allowing China to still buy the oil from Iran.
No, I didn't say that. We have the sanctions on. And if they do a job and if they can be peaceful and if they can show us they're not going to do any more harm, I would take the sanctions off. And the sanctions would make a big difference, as you know. When I was, we had a great success in the first term. We had the greatest economy in the history of our country. By the way, it's going to be absolutely, this is better. This is going to be, I think, even much better. But we had the greatest economy in history. And we use sanctions. You use them very carefully. Sanctions cost us a lot of money. It's not just, gee, we're going to put sanctions on. When you do sanctions, it costs a lot of money. But I would, one of the things I was thinking about doing, you start waiving them for countries like, if they behave themselves like Iran, where they can sell oil and they can do the things that you
So
want to
doesn't
be
he
able to do.
sound mad
The
controlling?
sanctions are very powerful, and it makes it difficult. I'm not looking to make it difficult. I want them to have a good life, but they were trying to develop a bomb, and the reason you try and develop a bomb like that is to use it.
But I want to get your take on China, really, because you've announced an agreement with the Chinese Communist Party, where China will export the rare earth minerals.
Yeah.
What does that mean in terms of this upcoming tariff structure? You've got a pause in terms of the more steep tariffs that ends August 12th. Are you going to extend that? Are you going to keep that in place or go back to a higher tariff on China?
China's going to be paying a lot of tariffs, but we have a big deficit. They understand that. I have a great relationship with President Xi. We have to do something about the deficit because we have a big trade deficit with China. Biden let it get up to $1 trillion. Think of it, $1 trillion deficit with one country. He let them just take them over the coals. We're not going to do that. But we're doing a rare earth deal, but we're also doing, remember, we have all of the airplane parts. They can't fly their airplanes without us. So we had, some cards also. But it should have never gotten that way because we should have been doing they call it magnets. It's a rare earth, but they call it magnets, a specific type. And they're making those magnets for us right now, and things are well. And we have a deal with China. It's a good deal, I think, hopefully for everybody. We had a deal with China where it was 145% tariffs, and I will tell you, everything stopped in China. I saw that everything stopped, and we did China a favor. But we're getting along well with China. I think getting along well with China is a very good thing. But they are paying substantial tariffs.
Well, I noticed that because it seems like you go so far with China, but you don't sort of use the leverage that you can use. I mean, look.
If I ever had to use it, I'd use it. But when there's no reason to use it, that's good too.
Well, we did just arrest 3 or 4 Chinese nationals who tried to bring a pathogen into the country that gets people sick and destroys food supply. We've got hacking.
You don't know where that
Wait,
came from.
what?
I mean, did that come from the country, or is that 3 wackos that happened to carry something? You just don't.
Yeah,
Well, there
hold
was
on.
one that he signed that he would be, one of them signed a paper saying that he would value Mao Zedong's value system. So there was that. And then they hack into our telecom system. They've been stealing intellectual property. They fentanyl, COVID. I mean, all of this stuff. So how do you negotiate with obviously a bad actor
You
and
don't think
trust
we do
them
that
on
to
economics?
them? You don't think we do that to them? We do.
So
We do a lot of
Hey,
things.
Trump just spit facts, bro. We do the same shit. People smuggle from us to them, and we bring bad things over. And dude, there we go. There's some facts right there.
It's the way the world works.
It's the way the world works.
and then you just do a trade deal?
We do. Well, we made a lot of money with this trade deal. I do a trade deal if it works. We made a lot of money with the trade deal.
You think that China is going to stop bullying companies to give them information in terms of in exchange for getting those rare earth minerals now?
Well, the companies shouldn't put themselves in that position. They really shouldn't. Now, I will say this: China right now needs those companies much more than they needed them 2 years ago. 2 years ago, China could do that. Today, they can't because they need those companies. They need Apple. They need all of, Apple's spending $600 billion, $700 billion in the United States building plants. They were never going to do that. Think of it, $700 billion. But a lot of the companies that are in China are now relocating back to the United States. So, yeah, China's going to treat them much better as they need them. They didn't need them under Biden because they were ripping us off left and right. They need them under Trump.
You just had a big success at NATO, getting the members to agree to spend more on defense. Is there anything you can do to get Congress to codify this? To get their governments to codify it?
You can. What you do, the best insurance is if they don't do it, you leave. You don't do business with them anymore. You don't do business. You have to have a certain trust, but you can also say trust but verify. But we're making unbelievable deals.
There is litigation around the legality of those tariffs. Are you going to be able to get more trade deals done before you hear from the International Court of Appeals in August?
Sure, but we won the litigation and we had the delay and we had some radical left judge and then we had it overturned. And we're doing well in all of our litigation. We're doing well on the tariff litigation. Look, if some judge said we can't do tariffs, we would fall prey to the rest of the world who would do tariffs and are doing tariffs on us. If we couldn't fight them back with tariffs, this country would be in terrible shape. We would be like this innocent lamb being led to slaughter. So, no, we're doing great on economics. We're doing great on tariffs. Tariffs is just a part of it. We're drilling like never before. That's how the oil got down low.
The Supreme Court victory that you got today, Friday, do you think that could apply to the tariff litigation that's pending here in terms of the legality of your tariffs? Does that affect that at all?
It could, but again, the tariff litigation, if you look at it, there are alternatives if we have to use them. They're not as good because they're not as direct. They're not as biting, but they're very good. So that you have alternatives, but we want to use this particular asset, this particular grouping, the words of this are so beautiful, they were meant for it. But what happens with the tariffs is that if a judge ruled against us, and this is part of how you win, fairness is also a part of the law. If a judge ruled against us on tariffs, we would fall prey to other countries destroying us. We can't do that. If they do tariffs on us, we do tariffs on them. If they charge us, we charge them. Then they never charge us.
Hey, it's Will.
Okay, guys, we'll comment on that a little bit. I agree with him. I agree with him on the tariff thing. I mean, it's not like we don't get charged. We get charged heavy tariffs. And in the past, we've gotten charged way more than other countries. So to that point of like us tariffing the others, yeah, no, I agree. Like, why wouldn't we? Why wouldn't we join the fray on that, quote unquote? Next thing we're going to watch is going to be the deadline for Trump's big, beautiful bill. So I'm trying to see a little bit more information.
We have Fox team
this.
coverage on this busy weekend in Washington. Madeline Rivera is at the White House where President Trump is following the action on the bill. But let's begin with senior congressional correspondent Chad Pergram. He's live on Capitol Hill. So set the stage for us, Chad. What's going on right now?
John, good afternoon. Well, Tom Tillis did not always align with President Trump. His retirement announcement triggered a shockwave on Capitol Hill. Tillis was one of 2 Republicans who voted against starting debate on the bill last night. President Trump lit up Tillis. He said Tillis was making a, quote, big mistake opposing the bill. He then threatened to primary Tillis. Tillis worried about health care provisions in the bill. Democrats boomeranged his opposition against the GOP.
The big and not very beautiful bill that we are about to vote on here in the Senate is going to cut $900 billion out of Medicaid. Don't believe me? Listen to Senator Tom Tillis. He's been saying loudly, this bill is a bad deal for the middle class. It'll raise health care costs and throw millions off of needed health care.
Tillis won his 2 previous races by about 2 percentage points. Tillis also had reservations until the last minute about supporting Pete Hegseth for Secretary of Defense. But even other Republicans from North Carolina see the bill differently from Tillis. Greg Murphy is a doctor.
The last thing as a physician I want to do is hurt a system that is already hurting as it is. But I also want to get back to the fact that there really are some things within the system as it is right now that are ridiculous and need to go away.
Democrats believe they can weaponize the big, beautiful bill against vulnerable Republicans.
What this does, and the baseline is all these cuts, all this cutback on health care to provide the wealthiest in our country a disproportionate share of tax cuts. That just doesn't seem fair. And the more we can get that out, I think this will be a political albatross.
Now, this means Tillis likely opposes the big, beautiful bill. GOP Kentucky Senator Rand Paul also voted nay last night. Senate Minority Leader Chuck Schumer compelled Senate clerks to read the entire 940-page bill out loud. That's gone on since 11 p.m. last night. Their voices are wavering.
In fiscal year 2026,
They are out of this. They're out
66 million to be derived from all contributions.
Just follow my lead, okay?
And to remain available until the end of fiscal year 2035 for the Director of Office to carry out such.
Chat, right after this, we will be covering this, by the way. We're going to cover the whole Senate thing on the big, beautiful bill. Do you bite your toenails? Fuck, no, hell no, bro.
Section C through F.
Now, just as we were listening to that soundbite of the clerk, John Thune, the majority leader, I should say, has taken the floor. They have ended reading this bill. Again, they were at it since 11:08 last night. And so this is the first time we've heard anybody on the Senate floor other than one of the Senate reading clerks going through that 940-page bill. This is Bernie Moreno, the Republican senator from Ohio, in the chair right now. So what we should have starting here very soon, John, is actual debate on the bill. Under the rules, there are up to 20 hours of debate. Now, we don't think that they will consume all of that. The Democrats will probably consume their 10 hours. It's split to 50-50. Republicans do want to talk for a little bit here, so we probably imagine, a few hours there, maybe 3 or 4, and then they start this lengthy vote series, which could alter the bill. That's what they call a vote-a-rama. That's where they take roll call vote after roll call vote after roll call vote. Now, again, there are amendments there that could change the bill, and that worries some House conservatives. But earlier this afternoon, I was texting back and forth with the Ways and Means Committee Chairman Jason Smith, and he tells Fox that about 85% of the tax provisions in the bill are the same as the House bill. So the Senate hopes to pass the bill Monday. The House could move later this week. So they're going to go through this debate that's starting right now. And then, that probably gets us into the overnight hours. And then they go to the vote-a-rama, the marathon voting session. John, what we've seen on these marathon voting sessions when we've had other so-called budget reconciliation bills on the floor, that's what this is they usually run between about 9 hours and 15 hours. So let's just do the time here. So let's say they take about 12 hours of debate. Okay, that gets us to a little bit after 1 in the morning. Then we're looking at this vote-a-rama, maybe starting 1 o'clock or so in the morning, maybe a little bit later. It's always a little bit later in the Senate because of what we call entry and booking time up here. It's kind of like soccer. So maybe at the earliest they could get to a roll call vote on final passage would be maybe 10 to 11 o'clock tomorrow morning. Worst case scenario, maybe, 1 or 2 in the afternoon. And that presumes, of course, that they have the votes. We talked about Senator Tillis. We talked about Rand Paul. You had Ron Johnson, the Republican senator from Wisconsin last night, who was a no on the board and then flipped his vote to yes after a lengthy conversation with Vice President Vance and also, with John Thune, the majority leader in his office. So they need Ron Johnson here. They can go down to 50 votes. As I always say, it's about the math. If it's 50-50, they can still have Vice President Vance break that tie and still pass the bill. But that is up in the air a little bit right now. We tend to think that they have this wrapped up, but you just don't know until the very end, especially because of Tom Tillis signaling that he was going to be a hard no and he's, going to retire at the end of his term. And that's to say nothing of the House. And that's why there's some concern there by these House conservatives about how the bill may...
This is a crazy bill to retire on. Guys, let me know, do we want to watch the whole debate, or do we want to watch them reading out the entire bill, or do we want to skip right to where they are now, like the live section?
Changed. Now, I pointed out what Jason Smith, the Ways and Means Committee chairman from Missouri, said earlier today, that there's not really that many changes. But that said, there are conservatives in the House who think this bill is different than what they passed on May 22nd, and they're very worried about, having this come back and the Senate essentially jamming them. I know some of the people in the leadership on the Republican side of the aisle in the House don't like that, but that is the reality with those rank and file members, especially on the conservative side of the aisle, the Chip Roys and some others. Back to you.
It's my understanding, Chad, that the Senate version of the bill is projected, at least, to increase the deficit. Do I have that right?
Yeah, there's a debt ceiling increase in this that's much bigger, about $5 trillion. It's a lot higher than the House debt ceiling increase. We believe that they will hit the debt ceiling in early August. The Congressional Budget Office, just in the past 2 weeks, has put that back a little bit, about mid-August to maybe September. You don't really know until you get close. So that's really the deadline. If for some reason they can't pass this by the 4th of July, they need to pass this by then, because that's the debt ceiling deadline.
I want to put up on the screen some of the key features of the bill that the Senate is voting on. One of them is new restrictions on Medicaid qualifications. Can you get into that a little bit? Because that seems to be angering a lot of Democrats.
Yeah, that's probably the most important thing besides the renewing the 2017 tax cuts to Republicans, where they say, okay, if you are an able-bodied person between about 18 and age 60, you need to go to work, 80 hours over the course of a month. You can also volunteer. You can also get some sort of, professional training or school. That would count toward that. But in order to qualify for those benefits, you need to go to work. And they're really hammering that. And one of the things I would watch in that vote-a-rama that's going to come up here is that there could be some roll call votes that Republicans engineer to weaponize against vulnerable Democrats who are up in 2026 and say, can you believe that they voted against this? And then when you get to late October next year, just before the midterm elections, they will turn those roll call votes that they engineer in the overnight tonight against those vulnerable Democrats and say, can you believe they voted against this or they voted for that or whatever it might be. Really what these vote-a-ramas are, this is really the first shot that's sometimes fired in the next election, because they try to design some of these roll call votes as a wedge against folks who represent a swing state.
We're going to take another look at some of the items that are in the Senate bill. Increasing the deficit, you talked about. The deficit goes up by about $3.3 trillion over the next 10 years. Now, a lot of House hawks are not going to like that. There's a $2,200 tax credit with proof of a Social Security number from one parent. And then there are deduction caps for taxes on overtime and tips. Then you go to the House side. The House version increases the deficit by about $2.5 trillion over the next 10 years. $2,500 tax credit with proof of Social Security number from both parents, and no deduction caps for taxes on overtime and tips. Which of those is going to be the most problematic for the House to resolve after it comes out of the Senate, do you think, Chad?
Well, the question is, does the House want to accept the Senate package? I mean, they were only able to pass their bill with one vote on May 22nd. And just the idea that whatever comes out of the Senate, unless they want this to go on for a much longer period of time and they play what we call parliamentary ping pong, where they bounce different versions of it back and forth and eventually, one side or the other wins, meaning the House or the Senate, they certainly won't get that done by the 4th of July if that's the case. Yeah, I mean, Nicole Maliotakis, who's a Republican from New York, indicated that maybe they could go to a conference committee. That's where you take a House bill and a Senate bill, and you get into a congressional blender, and you merge the bills, and then you produce what's called a conference report. It's basically a new bill. You send them both back to the House and Senate, and they have to adopt that revised, blended version.
But the president says he wants to sign something into law by the 4th of July, so it doesn't sound like that would please him, although I guess there is no hard and fast deadline here, right?
Well, he kind of said two different things on Friday. Publicly, there was an event where he was speaking Friday, and he said, it's not the end of the world if we're not done on the 4th. And then, just a couple of hours later on Truth Social, he put out another statement saying, imploring the House of Representatives to get this done. This is where some Republicans, frankly, when you talk to them off the record, they say, the main thing we want to do is get this done and get it done right. Cross the T's, dot the I's.
All right, Chad Pergram, our chief congressional correspondent, having a busy weekend. Thank you, Chad.
Thank you.
Hey, Sean Hannity here. Hey.
All right, chat, we're going to watch the live footage of the Senate on the big, beautiful bill. The question is, do we want to watch? I kind of looked at this earlier, and
good bill.
So it's
section for the most recently.
The first couple of hours of it, they read out the entire bill. So I'm going to let it play for a minute, but you guys let me know if you want to skip them reading out the bill and go right to the discussion, because I'm cool with skipping. But if y'all want to hear about it, we can hear about it. You know what I'm saying?
Conclude a fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the Consumer Price Index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the Consumer Price Index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for appealing Department of Homeland Security officer decisions during each fiscal year. A, not more than 25% of fees collected pursuant to the subsection 1 shall be derived from transfer from the immigration examinations fee account established under section 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation. And B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. G, fee for filing a motion to reopen or a motion to reconsider. 1, in general, except as provided in paragraph 3, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files a motion to reopen or a motion to reconsider a decision of an immigration judge or the Board of Immigration Appeals.
Now look, this is a like
2,
500
amount
page thing.
specified. A, initial
Check
amount.
the poll
For
if you
fiscal year
want to skip it.
2025, the amount specified in this paragraph shall be the greater of 1, $900, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 of the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year rounded to the next lowest multiple of $10. 3, exceptions. The fee required under paragraph 1 shall not apply. 2A, a motion to reopen a removal order entered in absentia if such motion is filed in accordance with section 240B 5C2, 8 U.S.C. 1229AB 5C2. Or B, a motion to reopen a deportation order entered in absentia if such motion is filed in accordance with section 242B C3B prior to April 1st, 1997. 4, disposition of fees for filing certain motions. During each fiscal year, A, not more than 25% of fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under sections 286M, 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration.
I'm about to end the poll in a minute, so everybody please vote on the poll. If you want to skip this explanation, please vote that. If you want to hear them say the whole 500-page bill, check that box.
Review. To retain and spend without further appropriation. And B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. H, fee for filing application for suspension of deportation. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court for suspension of deportation. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $600, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required in the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for filing application for suspension of deportation during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection shall be derived by transfer from the immigration examination fee account established under section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury. I, fee for filing application for cancellation of removal for certain permanent residents. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien at the time such alien files an application with an immigration court, an application for cancellation of removal for an alien who is a lawful permanent resident. 2, amount specified. A, initial amount. For fiscal year 2025, the amount specified in this paragraph shall be the greater of 1, $600, or 2, such amount as established by the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under this subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, round to the next lowest multiple of $10. 3, disposition of fees for filing application for cancellation of removal during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M, 8 U.S.C. 1356M, and 2, shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credited pursuant to subparagraph A shall be deposited into the general fund of the Treasury.
I'm in a Tsukuyomi, dude. This is insane. This is so
J,
much.
fee for filing an application for cancellation of removal and adjustment of status for certain non-permanent residents. 1, in general, in addition to any other fees authorized by law, the Attorney General shall require the payment of a fee equal to the amount specified in paragraph 2 by any alien who is not a lawful permanent resident at the time such alien files an application with an immigration court for cancellation, removal, and adjustment of status for any alien. 2, amount
She's
specified.
gonna quit her job after
A, initial
this.
amount.
She's
For
not
fiscal
coming
year
back to work
2025, the
tomorrow.
amount specified
I
in this paragraph
guarantee
shall be the
you.
greater of 1, $1,500, or 2, such amount as the Attorney General may establish by rule. B, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this paragraph shall be equal to the sum of 1, the amount of the fee required under the subsection for the most recently concluded fiscal year, and 2, the product resulting from the multiplication of the amount referred to in Clause 1 by the paragraph percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple of $10. 3, disposition of fees for filing application for cancellation or removal during each fiscal year. A, not more than 25% of the fees collected pursuant to this subsection 1 shall be derived by transfer from the immigration examinations fee account established under Section 286M 8 U.S.C. 1356M, and 2 shall be credited to the Executive Office for Immigration Review to retain and spend without further appropriation, and B, any amounts not derived by transfer and credit pursuant to subparagraph A shall be deposited into the general fund of the Treasury. K, limitation of use of funds, no fees
I can't even
collected
take
pursuant to
in
this
all this
section shall be
information,
expended
bro.
by the Executive Office for
Chad, are y'all
Immigration
getting all
Review
this?
for the Legal Orientation Program or for any successor program.
She said she needed a break. Bro, she said she needed a break. A whole ass break. When did she come back? Oh, someone else is about to take over. They're swapping up.
Section 100014, Electronic System for Travel Authorization Fee. Section 127H3B 8 U.S.C. 1187H3B is amended. 1, in Clause 1. A, in Subclause 1 by striking and at the end. B, in Subclause 2, I, by inserting of not less than $10 after an amount, and 2, by striking the period at the end and inserting semicolon, and C, by adding at the end of the following. 3, not less than $13 per travel authorization. 2, in Clause 3, by striking October 31, 2028, and inserting October 31, 2034, and 3, by adding at the end the following. 4, subsequent adjustment during fiscal year 2026 and each subsequent fiscal year. The amount specified in Clause 1(2) for a fiscal year shall be equal to the sum of 1, the amount of the fee required under the subparagraph during the most recent concluded fiscal year, and 2, the product of the amount referred to in Subclause 1 multiplied by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds consumer price index for all urban consumers for the same month of the preceding calendar year. Section 100015, Electronic Visa Update System Fee. A, in general, in addition to any other fee authorized by the law, the Secretary of Homeland Security shall require the payment of a fee in the amount specified in subsection B by any alien subject to the electronic visa update system at the time of such alien's enrollment in such system. B, amount specified. 1, in general, for fiscal year 2025, the amount specified in the subsection shall be the greater of A, $30, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and each subsequent fiscal year, the amount specified in the subsection shall be equal to the sum of A, the amount of the fee required under the subsection during the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage of any by which the consumer price index for all urban consumers for the month of July preceding the date on which adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the lowest multiple of 25 cents. cents. C, disposition of electronic visa update system fees. 1, in general, Section 286(8) U.S.C. 1356 is amended by adding at the end the following. W, CBP electronic visa update system account. 1, establishment. There is established in the general fund of the Treasury a separate amount which shall be known as the CPB electronic visa update system account. Refer to this in this subsection as the account. 2, deposits. There shall be deposited into the account an amount equal to the difference between A, all of the fees received pursuant to Section 100015 of the Act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Congress 14, 119th Congress, and B, an amount equal to $5 multiplied by the number of payments collected pursuant to each section. 3, appropriations. Amount deposited in the account, A, are hereby appropriated to make payments and offset program costs in accordance with Section 100015 of the Act entitled An Act to Provide for Reconciliation pursuant to Title II of H. Congress 14, 119th Congress, without further appropriation, and B, shall remain available until expended for any U.S. Customs and Border Protection costs associated with administering the CBP electronic visa update system. 2, remaining fees. Of the fees collected pursuant to this section, an amount equal to $5 multiplied by the number of payments collected pursuant to this section shall be deposited into the general fund of the Treasury. D, no fee waiver. Fees required to be paid under this section shall not be waived or reduced. Section 100016, fee for aliens ordered removed in absentia. A, in general, as partial reimbursement for the cost of arresting an alien described in the section, the Secretary of Homeland Security, except as provided in subsection C, shall require the payment of a fee equal to the amount specified in subsection B on any alien who, 1, is ordered removed in absentia pursuant to Section 240B5, 8 U.S.C. 1229A, B5, and 2, is subsequently arrested by U.S. Immigration and Customs Enforcement. B, amount specified. 1, initial amount for the fiscal year 2025. The amount specified in this section shall be the greater of A, $5,000, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this subsection in this section shall be equal to the sum of A, the amount of the fee required under this subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which such adjustments take effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded to the next lowest multiple, $10. C, exception. The fee described in this section shall not apply to any alien who was ordered removed in absentia if such order was rescinded pursuant to Section 240B5C, 8 U.S.C. 1229A, B5C. D, disposition of removal in absentia fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section A shall be credited to U.S. Immigration and Customs Enforcement. B, shall be deposited into the Detention and Removal Office fee account, and C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation. And 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. E, no fee waiver. Fees required to be paid under the section shall not be waived or reduced. Section 100017, an admissible alien apprehension fee. A, in general, in addition to any other fee authorized by the law, the Secretary of Homeland Security shall require the payment of a fee equal to the amount specified in subsection B by any inadmissible alien at the time of such alien is apprehended between ports of entry. B, amount specified. 1, initial amount. For fiscal year 2025, the amount specified in the section shall be the greater of A, $5,000, or B, such amount as the Secretary of Homeland Security may establish by rule. 2, annual adjustments for inflation. During fiscal year 2026 and during each subsequent fiscal year, the amount specified in this section shall be equal to the sum of A, the amount of the fee required under the subsection for the most recently concluded fiscal year, and B, the product resulting from the multiplication of the amount referred to in subparagraph A by the percentage, if any, by which the consumer price index for all urban consumers for the month of July preceding the date on which adjustment takes effect exceeds the consumer price index for all urban consumers for the same month of the preceding calendar year, rounded up to the next lowest multiple of $10. C, disposition of inadmissible alien apprehension fees. During each fiscal year, 1, 50% of the fees collected pursuant to this section, A, shall be credited to U.S. Immigration and Customs Enforcement, B, shall be deposited into the Detention and Removal Office fee account, and C, may be retained and expended by U.S. Immigration and Customs Enforcement without further appropriation, and 2, any amounts collected pursuant to this section are not credited to U.S. Immigration and Customs Enforcement pursuant to paragraph 1 shall be deposited into the general fund of the Treasury. D, disposition of inadmissible alien apprehension fees. All of the fees collected pursuant to the section shall be deposited into the general fund of the Treasury. Section 100018, amendment to authority to apply for asylum. Section 208D3, 8 U.S.C. 1158D3 is amended, 1, in the first sentence by striking may and inserting shall. 2, by striking such fees shall not exceed, and all that follows, and inserting the following. Nothing in this paragraph may be construed to limit the authority of the Attorney General to set additional adjudication and naturalization fees in accordance with Section 286M. Part 2, Immigration and Law Enforcement Funding, Section 100051, appropriation for the Department of Homeland Security. In addition to the amounts otherwise available, there is appropriated to the Secretary of Homeland Security for fiscal year 2025 out of any money in the Treasury not or otherwise appropriated $2.055 billion to remain available through September 30th, 2029 for the following purposes. 1, immigration and enforcement activities, hiring and training of additional U.S. Customs and Border Protection Agency and the necessary support staff to carry out immigration enforcement activities. 2, departures and removal, funding for transportation costs and related costs associated with the departure of or removal of aliens. 3, personal assignments, funding for the assignment of Department of Homeland Security employees and state officers to carry out immigration enforcement activities pursuant to sections 103A and 287G of the Immigration and Nationality Act, 8 U.S.C. 1103A and 1357G. 4, background checks, hiring additional staff and investing the necessary resource to enhance screening and vetting of all aliens seeking entry into the United States, consistent with Section 212 of such Act, 8 U.S.C. 1182, or intending to remain in the United States consistent with Section 237 of such Act, 8 U.S.C. 1227. 5, protecting alien children from exploitation. In instances of alien and alien children entering the United States without a valid visa, funding is provided for the purposes of A, collecting fingerprints in accordance with Section 262 of the Immigration and Nationality Act, 8 U.S.C. 1302, and subsections A, 3, and B of Section 235 of such Act, 8 U.S.C. 1225, and B, collecting DNA in accordance with Sections 235D and 287B of the Immigration and Nationality Act, 8 U.S.C. 1225D and 1357B. 6, transporting and return of aliens from contiguous territory. Transporting and facilitating the return pursuant to Section 235B2C of the Immigration and Nationality Act, 8 U.S.C. 1225B2C of aliens arriving from contiguous territory. 7, state and local participation. Funding for state and local participation in Homeland Security efforts for the purposes of A, ending the presence of criminal gangs and criminal organizations throughout the United States. B, addressing crime and public safety threats. C, combating human smuggling and trafficking networks throughout the United States. D, supporting immigration enforcement activities, and E, providing reimbursement for state and local participation in such efforts. 8, removal of specified unaccompanied alien children. A, in general, funding removal operations for specified unaccompanied alien children. B, use of funds. Amounts made available under this paragraph shall only be used for permitting a specified unaccompanied alien child to withdraw the application for admission of the child pursuant to Section 235A4 of the Immigration and Nationality Act, 8 U.S.C. 1225A4. C, definitions. In this paragraph, 1, specified unaccompanied alien child. The term specified unaccompanied alien child means unaccompanied alien child is defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who the Secretary of Homeland Security determines on a case-by-case basis. 1, has been found by an immigration officer at a land border or port of entry of the United States and is inadmissible under the Immigration and Nationality Act, 8 U.S.C. 1101 et sec. 2, has not been a victim of severe forms of trafficking in persons, and there is no credible evidence that such child is at risk of being trafficked upon return of the child to the child's country of nationality or country of last habitual residence, and 3, does not have a fear of returning to the child's country of nationality or country of last habitual residence owing to a credible fear of persecution. 2, severe forms of trafficking in persons. The term severe forms and trafficking in persons has the meaning given such term in Section 103 of the Trafficking Victims Protection Act of 2000, 22 U.S.C. 7102. 9, expedited removal of criminal aliens. Funding for the expedited removal of criminal aliens in accordance with the provisions of Section 235b1 of the Immigration Nationality Act, 8 U.S.C. 1225b1. 10, removal of certain criminal aliens without further hearings. Funding for the removal of certain criminal aliens without further hearings in accordance with the provisions of Section 235c of the Immigration and Nationality Act, 8 U.S.C. 1225c. 11, criminal and gang checks for unaccompanied alien children. Funding for criminal and gang checks of unaccompanied alien children is defined in Section 462G of the Homeland Security Act of 2002, 6 U.S.C. 279G, who are 12 years of age and older, including the examination of such unaccompanied alien children for gang-related tattoos and other gang-related markings. 12, information technology investments to support immigration purposes, including improvements to fee and revenue collections. Section 100052, appropriation for U.S. Immigration and Customs Enforcement. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for U.S. Immigration and Customs Enforcement for fiscal year 2025 out of any money in the Treasury not otherwise appropriated. $29,850,000,000 to remain available through September 30th, 2029 for the following purposes. 1, hiring and training additional U.S. Immigration and Customs Enforcement personnel, including officers, agents, investigators, and support staff to carry out immigration enforcement activities, and prioritizing the streamlining and hiring of retired U.S. Immigration and Customs Enforcement personnel. 2, performance, retention, and signing bonuses. A, in general, providing performance, retention, and signing bonuses for qualified U.S. Immigration and Customs Enforcement personnel in accordance with the subsection. B, performance bonuses. The Director of U.S. Immigration and Customs Enforcement, at the Director's discretion, may provide performance bonuses to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who demonstrates exemplary service. C, retention bonuses. The Director of U.S. Immigration and Customs Enforcement may provide retention bonuses to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who commits to 2 years of additional service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. D, signing bonuses. The Director of U.S. Immigration and Customs Enforcement may provide a signing bonus to any U.S. Immigration and Customs Enforcement agent, officer, or attorney who, 1, is hired on or after the date of the enactment of this act, and 2, who commits to 5 years of service with U.S. Immigration and Customs Enforcement to carry out immigration enforcement activities. E, service agreement. In providing a retention or signing bonus under this paragraph, the Director of U.S. Immigration and Customs Enforcement shall provide each qualifying individual with a written service agreement that includes 1, the commencement and termination dates of the required service period or provisions of the determination of such dates, 2, the amount of the bonus, and 3, any other term or condition under which the bonus is payable subject to the requirements of this paragraph, including 1, the condition under which the agreements may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in the subclause 1. 3, recruitment, hiring, and onboarding. Facilitating the recruitment, hiring, and onboarding of additional U.S. Immigration and Customs Enforcement personnel to carry out immigration enforcement activities, including by A, investing in information technology, recruitment, and marketing, and B, hiring staff necessary to carry out information technology, recruitment, and marketing activities. 4, transportation. Funding for transportation costs and related costs associated with alien departure or removal operations. 5, information technology. Funding for information technology investments to support enforcement and removal operations, including improvements to fee collections. 6, facility upgrades. Funding for facility upgrades to support enforcement and removal operations. 7, fleet modernization. Funding for fleet modernization to support enforcement and removal operations. 8, family unity. Promoting family unity by A, maintaining the care and custody during the period in which a charge described in Clause 1 is pending in accordance with the applicable laws of an alien who, 1, is charged only with a misdemeanor offense under Section 275A of the Immigration and Nationality Act, 8 U.S.C. 1325A, and 2, entered the United States with the alien's child who has not attained 18 years of age, and B, detaining such an alien with the alien's child. 9, 287G agreements, expanding, facilitating, and implementing agreements under Section 287G of the Immigration and Nationality Act, 8 U.S.C. 1357G. 10, Victims of Immigration Crime Engagement Office, hiring and training additional staff to carry out the mission of the Victims of Immigration Crime Engagement Office and for providing non-financial assistance to the victims of crime perpetrated by aliens who are present in the United States without authorization. 11, Office of the Principal Legal Advisor, hiring additional attorneys and the necessary support staff within the Office of the Principal Legal Advisor to represent the Department of Homeland Security and Immigration Enforcement and Removal Proceedings. Section 100053, Appropriation for Federal Law Enforcement Training Centers. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Secretary of Homeland Security for the Federal Law Enforcement Training Centers for fiscal year 2025 out of any money in the Treasury not otherwise appropriate $750 million to remain available until September 30th, 2029 for the purposes described in subsection B and C. B, training. Not less than $285 million of the amounts available under subsection A shall be for supporting the training of newly hired federal law enforcement personnel employed by the Department of Homeland Security and state and local law enforcement agencies operating in support of the Department of Homeland Security. C, facilities. Not more than $465 million of the amount available under subsection A shall be for procurement, construction, and maintenance of improvements to training equipment for and related expenses of facilities to the federal law enforcement training centers. Section 100054, appropriation for the Department of Justice. In addition to amounts otherwise available, there is appropriated to the Attorney General for the Department of Justice for fiscal year 2025 out of any money in the Treasury not otherwise appropriate $3,330 million to remain available through September 30th, 2029 for the following purposes. 1, Executive Office for Immigration Review. A, in general, hiring immigration judges and necessary support staff for the Executive Office for Immigration Review to address the backlog of petitions, cases, and removals. B, staffing levels. Effective November 1, 2028, the Executive Office for Immigration Review shall be comprised of not more than 800 immigration judges along with the necessary support staff. 2, combating drug trafficking. Funding efforts to combat drug trafficking, including trafficking of fentanyl and its precursor chemicals and illegal drug use. 3, prosecution of immigration matters. Funding efforts to investigate and prosecute immigration matters, gang-related crimes involving aliens, children trafficking, and smuggling involving aliens within the United States, unlawful voting by aliens, violations of the Alien Registration Act, 1940, 54 Stat, Chapter 439, and violation of or fraud relating to Title IV of the Personal Responsibility and Work Opportunity Act of 1996, Public Law 104-193, 110 Stat 2277, including hiring additional Department of Justice personnel to investigate and prosecute such matters. 4, non-party or other injunctive relief. Hiring additional attorneys and necessary support staff for the purpose of continuing implementation of assignments by the Attorney General pursuant to Sections 516, 517, and 518 of Title 28 United States Code to conduct litigation and tend to the interests of the United States in suits pending in a court of the United States or in a court of the state in suits seeking non-party or other injunctive reliefs against the federal governments. 5, Edward Byrne Memorial Assistance Grant Fund and Office of Community-Oriented Policing. In general, increasing funds for the Edward Byrne Memorial Justice Assistance Grant Program and the Office of Community-Oriented Policing for initiatives associated with investigating and prosecuting violent crime. 2, criminal enforcement initiatives. And 3, immigration enforcement and removal efforts. B, limitations. No funds made available under this subsection shall be made available to community violence intervention and prevention initiative programs. C, eligibility. To be eligible to receive funds made available under the subsection, a state or local government shall be in full compliance as determined by the Attorney General with Section 642 of the Legal Immigration Reform and Immigrant Responsibility Act of 1996, 8 U.S.C. 1373. 6, fiscally responsible lawsuit settlements, hiring additional attorneys and necessary support staff for the purposes of maximizing lawsuit settlements that require the payment of fines and penalties to the Treasury of the United States in lieu of providing for the payment to any person or entity other than the United States, other than a payment that provides restitution or otherwise directly remedies actual harm directly in proximity caused by the party making the payment, or constitutes payment for services rendered in connection with the case. 7, compensation for incarceration of criminal aliens. A, in general, providing compensation to a state or political subdivision of a state for the incarceration of criminal aliens. B, use of funds. The amounts made available under subparagraph A shall only be used to compensate a state or local subdivision of a state as appropriate with respect to the incarceration of an alien who, 1, has been convicted of a felony or 2 or more misdemeanors, and 2, 1, entered the United States without inspection or at any time or place other than designated by the Secretary of Homeland Security. 2, was the subject of removal proceedings at the time the alien was taken into custody by the state or a political subdivision of the state, or 3, was admitted as a non-immigrant and at the time the alien was taken into custody by the state or a political subdivision of the state had failed to maintain the non-immigrant status in which the alien was admitted or to which it was changed or to comply with the conditions of any such status. C, limitation. Amounts made available under the subsection shall be distributed to more than one state. The amounts made available under subparagraph A may not be used to compensate any state or political subdivision of a state if the state or political subdivision of the state prohibits or in any way restricts a federal, state, or local government entity, official, or other personnel from doing any of the following. 1, complying with the immigration laws as defined in Section 101A.17 of the Immigration Nationality Act, 8 U.S.C. 1101A.17. 2, assisting or cooperating with federal law enforcement entities, officials, or other personnel regarding the enforcement of the immigration laws. 3, undertaking any of the following law enforcement activities as such activities relate to information regarding the citizenship or immigration status, lawful or unlawful, the admissibility or deportability, and the custody status of any individual. 1, making inquiries to any individual to obtain such information regarding such individual or any other individuals. 2, notifying the federal government regarding the presence of individuals who are encountered by law enforcement officials or other personnel of the state or political subdivision of a state. 3, complying with requests with such information from federal law enforcement entities, officials, or other personnel. Section 100055, Bridging Immigration-Related Deficits Experience Nationwide Reimbursement Fund. A, establishment. There is established within the Department of Justice a fund to be known as the Bridging Immigration-Related Deficit Experience Nationwide Biden Reimbursement Fund, referred to in this section as the fund. B, use of funds. The Attorney General shall use amounts appropriated or otherwise made available for the funds for grants to eligible states, state agencies, and units of local government pursuant to their existing statutory authorities for any of the following purposes. 1, locating and apprehending aliens who have committed a crime under federal, state, or local law in addition to being unlawfully present in the United States. 2, collection and analysis of law enforcement and investigation information within the United States to counter gang or other criminal activity. 3, investigating and prosecuting A, crimes committed by aliens within the United States, and B, drug and human trafficking crimes committed within the United States. 4, court operations related to the prosecution of A, crimes committed by aliens, and B, drug and human trafficking crimes. 5, temporary criminal detention of aliens. 6, transporting aliens described in paragraph 1 within the United States to locations related to the apprehension, detention, and prosecution of such aliens. 7, vehicle maintenance, logistics, transportation, and other support provided to law enforcement agencies by state agencies to enhance the ability to locate and apprehend aliens who have committed crimes under federal, state, or local law in addition to being unlawfully present in the United States. C, appropriation. In addition to amounts otherwise available for the purposes described in subsection B, there is appropriated to the Attorney General for fiscal year out of any money in the Treasury not otherwise appropriated, not to exceed $3.5 trillion to remain available until September. $3.5 billion to be remain available until September 30th, 2028 for the fund of qualified and documented expenses that achieve such purpose. D, grant eligibility for completed, ongoing, or new activities. The Attorney General may provide grants under this section to state agencies and units of local government for expenditures made by state agencies or local government for completed, ongoing, or new activities determined to be eligible for such grant funding that occurred on or after January 20th, 2021. Amounts made available under this section shall be distributed to more than one state. Section 100056, appropriation for the Bureau of Prisons. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of Bureau of Prisons for fiscal year 2025 out of any money in the Treasury not otherwise appropriated $5 billion to remain available through September 30th, 2029 for the purposes described in subsections B and C. Salaries and benefits, not less than $3 billion of the amount made available under subsection A shall be for hiring and training of new employees, including correctional officers, medical professionals, and facilities and maintenance employees, the necessary support staff, and for additional funding for salaries and benefits for the current workforce of the Bureau of Prisons. C, facilities, not more than $2 billion of the amount made available under subsection A shall be for addressing maintenance and repairs to facilitate, maintained, or operated by the Bureau. Repairs to facilities maintained or operated by the Bureau of Prisons. Section 10057, appropriation for the United States Secret Service. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the United States Secret Service, referred to in the section as the Director, for fiscal year 2025, out of any money in the Treasury not otherwise appropriate, $1.170 billion to remain available through September 30th, 2029 for the purpose described in subsection B. B, use of funds. Amounts made available under subsection A may only be used for 1, additional U.S. Secret Service resources, including personnel, training facilities, programming, technology, and 2, performance, retention, and signing bonuses for qualified United States Secret Service personnel in accordance with subsection C. C, performance, retention, and signing bonuses. 1, performance bonuses. The Director, at the Director's discretion, may provide performance bonuses to any Secret Service agent, officer, or analyst who demonstrates exemplary service. 2, retention bonuses. The Director may provide retention bonuses to any Secret Service agent, officer, or analyst who commits to 2 years of additional service within the Secret Service. 3, signing bonuses. The Director may provide a signing bonus to any Secret Service agent, officer, or analyst who, A, is hired on or after the date of the enactment of this act, and B, commits to 5 years of service within the United States Secret Service. 4, service agreement. In providing retention or signing bonus under the subsection, the Director shall provide each qualifying individual with a written service agreement that includes A, the commencement and termination dates of the required service period or provisions for the determination of such date, B, the amount of the bonus, and C, any other term or condition under which the bonus is payable, subject to the requirements under the subsection, including 1, the conditions under which the agreement may be terminated before the agreed upon service period has been completed, and 2, the effect of the termination described in clause 1. Subtitle B, judiciary matters. I'm going to do that.
Section 100101, appropriation to the Administrative Office of the United States Courts. In addition to amounts otherwise available, there is appropriated to the Director of the Administrative Office of the United States Courts, out of the amounts in the Treasury not otherwise appropriated, $1,250,000 for each fiscal years 2025 through 2028 for the purpose of continuing analyses and reporting pursuant to Section 604A2 of Title 28 United States Code, to examine the state of the dockets of the courts and to prepare the transmit statistical data and reports as to the business of the courts, including an assessment of the number, frequency, and related metrics of judicial orders issuing non-party relief against the federal government and their aggregate cost impact on the taxpayers of the United States, as determined by each court when imposing securities for the issuance of preliminary injunctions or temporary restraining orders against the federal government pursuant to Rule 65C of the Federal Rules of Civil Procedure. Section 100102, appropriation to the Federal Judicial Center. A, appropriation. In addition to amounts otherwise available, there is appropriated to the Director of the Federal Judicial Center, out of amounts in the Treasury not otherwise appropriated, $1 million for each of fiscal years 2025 through 2028 for the purpose described in subsection B. B, use of funds. The Federal Judicial Center shall use the amounts appropriated under subsection A for the continued implementation of programs pursuant to Section 620B3 of Title 28 United States Code to stimulate, create, develop, and conduct programs of continuing education and training for personnel of the judicial branch, including training on the absence of constitutional and statutory authority, supporting legal claims that seek non-party relief against the federal government, and strategic approaches for mitigating the aggregate cost impact of such legal claims on the taxpayers of the United States. Subtitle C, radiation exposure compensation matters. Section 100201, extension of a fund. Section 3D of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1, by striking the first sentence and inserting the fund shall terminate on December 31, 2028, and 2, by striking the end of that 2-year period and inserting such date. Section 100202, claims relating to atmospheric testing. A, leukemia claims relating to Trinity test in New Mexico and test in the Nevada site. Section 4A1A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended 1 in Clause 1A and Subclause 1 by striking October 31, 1958, and inserting November 6, 1962. B in Subclause 2, 1 by striking in the affected area and inserting in an affected area, and 2 by striking or after the semicolon. C by redesignating Subclause 3 as Subclause 4, and D by inserting after Subclause 2 the following. 3, was physically present in an affected area for a period of at least 1 year during the period beginning on September 24, 1944 and ending on November 6, 1962, and 2 in Clause 2, 1 of striking physical presence described in Subclause 1 or 2 of Clause 1, or on-site participation described in Clause 1, 3, and inserting physical presence described in Subclause 1, 2, or 3 and Clause 1 or on-site participation described in Clause 1, 4. B, amounts for claims relating to leukemia, Section 4A1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended 1 in subparagraph A by striking an amount and inserting the amount. 2, by striking subparagraph B and inserting the following. B, amount. If the conditions described in subparagraph C are met, an individual who is described in subparagraph A shall receive $100,000, and 3, in subparagraph C, by adding at the end the following. 4, no payment under this paragraph previously has been made to the individual on behalf of the individual or to a survivor of the individual. C, conditions for claims related to leukemia, Section 4A1C of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended 1 by striking Clause 1 and 2 by redesignating Clauses 2 and 3 as Clauses 1 and 2 respectively. D, specified diseases claims relating to the Trinity test in New Mexico and test at the Nevada site, Section 4A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended 1 in subparagraph A by striking in the affected area and inserting in an affected area. B, by striking 2 years and inserting 1 year. And C, by striking October 31, 1958 and inserting November 6, 1962. 2 in subparagraph B, A, by striking in the affected area and inserting in an affected area, and B, by striking or at the end of inserting a semicolon. 3, by redesignating subparagraph C as subparagraph D, and 4, by inserting after subparagraph B the following. C, was physically present in an affected area for a period of at least 1 year during the period beginning of September 24, 1944, and ending on November 6, 1962. Or E, amounts for claims related to specified diseases, Section 4A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended in the matter following subparagraph D as redesignated by subsection D of this section. 1, by striking $50,000 in the case of an individual described in subparagraph A or B, or $75,000 in the case of an individual described in subparagraph C, and inserting $100,000. 2, Clause 1, by striking and inserting a semicolon. 3, in Clause 2, by striking the period at the end and inserting and 4, by adding at the end the following. 3, no payment under this paragraph previously has been made to the individual or on behalf of the individual or to a survivor of the individual. F, downwind states. Section 4B1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended to read as follows. 1, affected area means A, except as provided under subparagraph B. 1, the states of New Mexico, Utah, and Idaho. 2, in the state of Nevada, the counties of White Pine, Nye, Lander, Lincoln, Eureka, and that portion of Clark County that consists of townships 13 through 16 at ranges 63 through 71, and 3, in the state of Arizona, the counties of Coconino, Yavapai, Navajo, Apache, Gila, and Mojave, and B, with respect to a claim by an individual under subsection A1, A1, 3, or subsection A2C, only New Mexico, and Section 100203, claims relating to uranium mining. A, employees of mines and mills, Section 5A1A1 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended to read as follows. 1. As employed in a uranium mine or uranium mill, including an individual who is employed in the transport of uranium ore or vanadium uranium ore from such mine or mill located in Colorado, New Mexico, Arizona, Wyoming, South Dakota, Washington, Utah, Idaho, North Dakota, Oregon, or Texas at any time during the period beginning on January 1, 1942 and ending on December 31, 1990, or 2, was employed as a core driller in a state referred to in a subclause 1 during the period described in such subclause, and B, minors, Section 5A1A21 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended by inserting or renal cancer or any other chronic renal disease, including nephritis and kidney tubal tissue injury after non-malignant respiratory disease. C, millers, core drillers, and ore transporters. Section 5A1A22 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note is amended 1 by inserting core driller after was a miller, 2 by inserting or was involved in remediation efforts at such a uranium mine or uranium mill after ore transporter, 3 by inserting 1 after clause 1, and 4 by striking or renal cancers and all that follow and inserting or renal cancer or any other chronic renal disease, including nephritis and kidney tubal tissue injury, or D, combined work histories, Section 5A1A2 of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 22 note, as amended by subsection C, is further amended 1 in subclause 1 by striking or at the end, and 2 by adding at the end the following. 3AA does not meet the conditions of subclause 1 or 2. BB worked during the period described in clause 1, or in 2 or more of the following positions: miner, miller, core driller, and ore transporter. CC meets the requirements under paragraph 4 and 5. And D submits written medical documentation that the individual developed lung cancer, a non-malignant respiratory disease, renal cancer, or any other chronic renal disease, including nephritis and kidney tubal tissue injury, after exposure to radiation through work in 1 or more of the positions referred to in item B. E, special rules relating to combined work histories, Section 5A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, as amended by adding at the end the following. Special rule 4, special rule relating to combined work histories for individuals with at least 1 year of experience. An individual meets the requirements under this paragraph if the individual worked in 1 or more of the positions referred to in paragraph 1A23BB for a period of at least 1 year during the period described in paragraph 1A11. 5, special rule relating to combined work histories for minors. An individual meets the requirements of this paragraph if the individual during 1A11 worked as a minor and was exposed to such number of working level months that the Attorney General determines, when combined with the exposure of such individual to radiation through work as a miller, core driller, or transporter during the period described in paragraph 1A11, results in such individual being exposed to a total level of radiation that is greater or equal to the level of exposure of an individual described in paragraph 4. F, definition of core driller. Section 5B of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended 1 in paragraph 7 by striking and at the end, 2 in paragraph 8 by striking the period at the end and inserting and 3 by adding at the end the following. 9, the term core driller means any individual employed to engage in the act or process of obtaining cylindrical rock samples of uranium or vanadium by means of a borehole drilling machine for the purpose of mining uranium or vanadium. Section 100204, claims relating to Manhattan Project waste. The Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended by inserting after Section 5 the following. Section 5A, claims relating to Manhattan Project waste. A, in general, a claimant shall receive compensation for a claim made under this act as described in subsection B or C if 1, a claim for compensation is filed with the Attorney General, A, by an individual described in paragraph 2, or B, on behalf of that individual by an authorized agent of that individual if the individual is deceased or incapacitated, such as 1, an executor of estate of that individual, or 2, a legal guardian conservative of that individual. 2, that individual, or if applicable, an authorized agent of that individual demonstrates that such individual, A, was physically present in an affected area for a period of at least 2 years after January 1, 1949, and B, contracted a specified disease after such period of physical presence. 3, the Attorney General certifies that the identity of that individual, and if applicable, the authorization of that individual is not fraudulent or otherwise misrepresented. And 4, the Attorney General determines that the claimant has satisfied the applicable requirements of this Act. B, losses available to living affected individuals. 1, in general, in the event of a claim qualifying for compensation under subsection A that is submitted by the Attorney General to be eligible for compensation under this section at a time when the individual described in subsection A2 is living, the amount of compensation under this section shall be in an amount that is greater of $50,000 or the total amount of compensation for which the individual is eligible under paragraph 2. 2, losses due to medical expenses. A claimant described in paragraph 1 shall be eligible to receive upon submission of contemporaneous written medical records, reports, or billing statements created by or at the direction of a licensed medical professional who provided contemporaneous medical care to the claimant, additional compensation in the amount of all documented out-of-pocket medical expenses incurred as a result of the specified disease suffered by that claimant, such as any medical expenses not covered, paid for, or reimbursed through A, any public or private health insurance, B, any employee health insurance, C, any workers' compensation program, or D, any other public, private, or employee health program or benefit. 3, limitation. No claimant is eligible to receive compensation under this subsection with respect to medical expenses unless the submission described in paragraph 2 with respect to such expenses are submitted on or before December 31, 2028. C, payments to beneficiaries or deceased individuals in the event that an individual described in subsection A2 who qualifies for compensation under subsection A is deceased at the time of submission of the claim. 1, a surviving spouse may, upon submission of a claim and records sufficient to satisfy the requirements of subsection A with respect to the deceased individual, receive compensation in the amount of $25,000, or 2, in the event that there is no surviving spouse, their surviving children, minor or otherwise, of the deceased individual may, upon submission of a claim and records sufficient to satisfy the requirements of subsection A with respect to the deceased individual, receive compensation in the total amount of $25,000 paid in equal shares to each surviving child. D, affected areas. For purposes of this section, the term affected area means 1, in the state of Missouri, the zip codes of 63031, 63033, 63034, 63042, 63045, 63074, 63114, 63135, 63138, 63044, 63121, 63140, 63145, 63147, 63102, 63304, 63134, 63043, 63341, 63368, and 63367. 2, in the state of Tennessee, the zip codes of 37716, 37840, 37719, 37748, 37763, 37828, 37769, 37710, 37845, 37887, 37829, 37854, 37830, and 37831. 3, in the state of Alaska, the zip codes of 99546 and 99547, and 4, in the state of Kentucky, the zip codes of 42001 and 42003 and 42086. E, specified disease. For purposes of this section, the term specified disease means any of the following. A, 1, any leukemia provided that the initial exposure occurred after 20 years of age and the onset of the disease was at least 2 years after the first exposure. 2, any of the following diseases provided that the onset was at least 2 years after the initial exposure. A, multiple myeloma. B, lymphoma other than Hodgkin's disease. C, primary cancer of the 1, thyroid. 2, male or female breasts. 3, esophagus. 4, stomach. 5, pharynx. 6, small intestine. 7, pancreas. 8, bile ducts. 9, gallbladder. 10, salivary gland. 11, urinary bladder. 12, brain. 13, colon. 14, ovary. 15, bone. 16, renal. 17, liver, except if cirrhosis or hepatitis B is indicated, or 18, lung. F, physical presence. 1, in general. For purposes of this section, the Attorney General may not determine that a claimant has satisfied the requirements under subsection A unless demonstrated by submission of A, contemporaneous written residential documentation, or at least one additional employer-issued or government-issued document or record that the claimant, for at least 2 years after January 1, 1949, was physically present in an infected area, or B, other documentation determined by the Attorney General to demonstrate that the claimant, for at least 2 years after January 1, 1949, was physically present in an affected area. 2 types of physical presence. For purposes of determining physical presence under this section, A claimant shall be considered to have been physically present in an affected area if A, the claimant's primary residence was in the affected area, B, the claimant's place of employment was in an affected area, or C, the claimant attended school in the affected area. G, disease contraction in affected areas. For purposes of this section, the Attorney General may not determine that a claimant has satisfied the requirements under subsection A unless the claimant submits 1, written medical records or reports created by or at the direction of a licensed medical professional, created contemporaneously with the provision of medical care to the claimant, that the claimant, after a period of physical presence in an affected area, contracted a specific disease, or 2, other documentation determined by the Attorney General to demonstrate that the claimant contracted a specified disease after a period of physical presence in an affected area. Section 100205, Limitations on Claims, Section 8A of the Radiation Exposure Compensation Act, Public Law 101-426, 42 U.S.C. 2210 note, is amended by striking 2 years after the date of enactment of the RECA Extension Act of 2022 and inserting December 31, 2027.
Mr. President.
I recognize the Majority Leader.
Thank you, Mr. President. Mr. President, I would like to start by just taking a moment to thank the clerks who stayed up all night reading the amendment and getting us to this point. I know it was a long night and that we're not finished yet, but I want them to know that the Senate appreciates their dedication, their stamina, and their service. In just a moment, I'm going to make a point of order against the substitute amendment that I offered on behalf of Chairman Graham. I believe the chair should rule that there is no point of order against the amendment because the Budget Act, under the Budget Act, I should say, the Senate looks to the Budget Committee to assess the budgetary effects of an amendment. Basically, this has to do with the current policy baseline that we decided to use in the budget resolution for this bill and how we handle points of order related to it. This is an issue that I think we need to deal with right off the bat. Therefore, I make a point of order under Section 313B1E of the Congressional Budget Act against the substitute amendment number 2360.
Under the Congressional Budget Act and the precedents of the Senate, the chair must rely on determinations made by the Budget Committee in assessing the budgetary effects of the amendment. Section 312 of the Budget Act states, for the purposes of this title and Title IV, the levels of new budgetary authority, outlays, direct spending, new entitlement authority, and revenues for a fiscal year shall be determined on the basis of estimates made by the Committee on the Budget of the House of Representatives or the Senate as applicable. Unless the Budget Committee, speaking through its chairman, asserts that the amendment causes a violation of the Budget Act, the chair will not so hold. The point of order is not well taken.
Mr. President.
I recognize the Democrat leader.
I appeal the ruling of the chair, and I ask for the yeas and nays.
The yeas and nays are ordered. The appeal is debatable for 1 hour under this act. Sorry, is there a sufficient second? There appears to be. The yeas and nays are ordered.
Mr. President.
I recognize the Democrat leader.
Mr. President, first, let me thank everyone who stayed overnight to take part in the reading of this bill. My colleagues, the cloakrooms, the floor staff, everyone who made it possible. I would say this to the cloakrooms and particularly our great floor staff. You are all amazing. You're the unsung heroes of what goes on here. Without you, none of us could do our work. So thank you for your dedication, your excellence, your perseverance, your strength. Now, Senate Democrats will now commence 4 parliamentary inquiries to show the hypocrisy of what Republicans are trying to do here in the Senate and to expose how they're trying to hide the true costs of their billionaire giveaways to the American people. I thank my colleagues who will speak momentarily, as well as all of my colleagues who have come to the floor as we debate this bill before Vote-A-Rama. So before I yield to them, I just want to hammer home exactly what is going on here in the Senate for the people back home. Republicans are about to pass the single most expensive bill in U.S. history to give tax breaks to billionaires while taking away Medicaid, SNAP benefits, and good-paying jobs for millions of people. CBO just this morning said it will explode the debt by $3.3 trillion. And they said it will likely cost more over time. More than that, closer to $4 trillion. Rather than be honest with the American people about the true costs of their billionaire giveaways, Republicans are doing something the Senate has never done before, deploying fake math and accounting gimmicks to hide the true cost of their bill. Look, Republicans can use whatever budgetary gimmicks they want to try and make the math work on paper, but you can't paper over the real-life consequences of adding tens of trillions to the debt. Sky-high interest rates, higher borrowing costs for cars, for homes, for credit cards. Americans are going to feel this, unfortunately, everywhere they look. Americans' household wealth will be permanently hobbled. There aren't enough budgetary gimmicks in the world to change that fact. And for what? Why are Republicans doing this? So that billionaires can pay less in taxes while tens of millions lose their health care benefits and pay more for everyday expenses. I now yield to my colleague from Oregon for the first parliamentary inquiry.
Mr. President.
I recognize the senator from Oregon.
Parliamentary inquiry.
The senator will state his inquiry.
When the House bill was first laid before the Senate, was the operative baseline under which it would be considered the current law baseline under Section 257 of the Balanced Budget and Emergency Deficit Control Act of 1985?
Yes.
Thank you.
I recognize the Democrat leader.
I rise for a parliamentary inquiry.
The senator will state his inquiry.
Has the Senate ever used a baseline other than current law baseline under 257 for enforcement of budget points of order, including under Section 313 of the Budget Act, during the consideration of a reconciliation measure? Has it ever been used?
No.
Mr. President.
Recognize the senator from Oregon.
Mr. President, when the Republican majority is going to the floor, what they're doing is hiding trillions of dollars in handouts to corporations and the wealthy. Trillions of dollars. If you measure this bill the way we measure every other reconciliation bill, it simply doesn't comply with the rules. But the Republican majority has figured out a trick that allows them to sidestep the parliamentarian, violate the Congressional Budget Act, and lift the filibuster for Trump's entire legislative agenda in one fell swoop. It is fakery. The budget numbers are a fraud, but the deficits will be very real. The prospect of a catastrophic debt spiral is very real. The hardship this terrible bill is going to inflict on tens of millions of Americans will be very real. So my parliamentary inquiry will proceed now. Does the score of the finance title of the Senate substitute, which the chairman asserts complies with its instruction, rely on the use of two distinct baselines, current policy for taxes and current law for health provisions like Medicaid?
Yes. Mr. President. I recognize the senator from Washington.
Mr. President, parliamentary inquiry.
The senator will state their inquiry.
Are the remaining 9 titles of the Senate substitute scored by CBO using a current law 257 baseline?
Yes.
Mr. President.
I recognize the senator from Washington.
Mr. President, I've been here a long time. Not only have I been the budget chair, I am the longest serving Democrat on that committee. And in my 33 years here in the United States Senate, things have never worked this way, where one party so egregiously ignores precedent, process, and the parliamentarian, and does that all in order to wipe away trillions of dollars of costs for a bill that could just be the most expensive legislation this body ever passes. Forget Senate procedure for a minute. Math, Mr. President, has never worked that way. I taught preschool, and I'll tell you, even our littlest kids knows the difference between a trillion and 0. It doesn't take a preschooler to tell you they're using magic math, or that you can't just ignore the rules you don't like How many times have my colleagues cried about the debt? How many times have they told me, I know you want to invest in childcare, Patty, but we got to get this budget under control. But now that it's tax cuts for billionaires and corporations, suddenly the budget doesn't matter anymore. Suddenly the rules do not matter anymore. Suddenly a couple trillion goes away with a sprinkle of fairy dust. And bypassing the parliamentarian and president isn't really bypassing if you just close your eyes and just pretend real hard. Have you no shame? If you think you can look the American people in the face and tell them we have to bring down the debt after passing what might be the most expensive bill in history, if you think you can do that and then be taken seriously, well, you know what? If you believe that, maybe you are foolish enough to think that 0 and a trillion are the same. Mr. President, I can't believe this is what we're doing today. Because I can tell you right now, if this happens, we will all laugh you out of the room because we have never seen anything like this. Not in my time here in the Senate, not in my time on this planet. We are not going to let anyone forget that you're trashing the rules in order to pass this egregious bill. I yield the floor.
Mr. President.
I recognize the senator from Oregon.
Thank you. I want to share a couple comments with my colleagues, including my Republican colleagues, because I've made these points on the floor, but generally the floor is empty, and some of you are here now. In 1974, 100 senators agreed on reconciliation as a fast-track, filibuster-free, but only for one purpose, reducing the deficit. It had three pillars: reduce the deficit over a 10-year period. Second, reduce the deficit in each and every year after that 10-year period, in each title of the bill. And third, use honest numbers. In 1996, the Republican team was in the majority and decided on a nuclear option to allow that reconciliation process to be used to increase deficits in the 10-year window. That was unfortunate because it destroyed the agreement all 100 senators had agreed to in 1974. But now, today, if we proceed with this current policy baseline, there's two other pillars that you're destroying of the architecture to create fiscal discipline. The second pillar was no deficits after the 10-year period. That's been destroyed. And the third was to use honest numbers from the Congressional Budget Office on a current law basis, comparing each provision in the bill as compared to the provision not being in the bill. So here we are, taking a step that is as significant as it was in 1996. All three pillars will be brought down, not by Democrats, but by Republicans. It's not necessary to do this to get what you want within the 10-year period. Why tear down these additional two pillars of honesty about the numbers, no more smoke and mirrors, and creating deficits after the 10-year period? It's extremely unfortunate if you press forward with that vision in this bill. President.
Mr. President,
I recognize the senator from Oregon.
I want to pick up on the point that my colleague from Washington State touched on. Everybody ought to understand this is the nuclear option. It's just hidden behind a whole lot of Washington, D.C. lingo. The only difference is instead of pressing a big nuclear button right at the beginning of the Congress, Republicans decided that they'd hide behind a cloak of Senate procedure and go nuclear for every individual bill they want to pass on party lines. And I just say to my colleagues, there's going to be a lot of horrendous messes to clean up after this legislation. But my colleagues need to understand the moves, as my colleague from Washington State has said, cut both ways. I yield the floor.
Mr. President. I recognize the Democrat leader.
I ask that debate time come off the bill unless otherwise advised.
Without objection.
Mr. President.
I recognize the senator from Rhode Island.
In this place where big money now rules and in which fakery is now the order of the day and numbers no longer have to be real, there is one point that stands out, and that is that the fakery on the floor is belied by the language of the bill. If these assertions were true, they would not need to raise the debt limit. All of this fun and games, all of this parliamentary mischief that is happening right now crashes into the fact that in real markets, in the real world, outside of this fakery, the debt limit is actually a real thing. And I will take a moment to read from page 754 of this midnight monstrosity what it actually says, where it collides with the real world. Subtitle C, Increase in Debt Limit. Section 72001, Modification of Limitation on the Public Debt. Line 20. The limitation under Section 3101B of Title 31 United States Code, as most recently increased by Section 401B of Public Law 118.5, 31 U.S.C. 3101 Note, is increased by $5 trillion. $5 trillion. That's the real number here. That's where the rubber hits the road in real life. The maneuver that is being pulled right now to avoid that fact, the fact that the debt limit has to be increased by $5 trillion so that Republicans can give immense tax breaks to billionaires, has not been used for this before. I used it once. In the year 2000, a deal had been struck on how to score activities of the Power Marketing Administration. Does anybody really know about the Power Marketing Administration? It's a small thing. Over the years, the Congressional Budget Office started scoring the program differently than the Senate had agreed to in 2000. So, Budget Chair, me, and the House Budget Chair, Jody Arrington, on a bipartisan basis, invoked this section to have CBO return to the original Senate agreement and not the variation that they had created. This is what Section 312 has been used for, to resolve technical ambiguity to advance a bipartisan appropriation deal, not to create Senate floor fakery belied by the $5 trillion debt limit hike that Republicans are obliged to pass to make good on this huge billionaire blowout that we're forcing through the Senate floor now. I yield the floor.
I recognize the senator from South Carolina.
I am using and yielding time off the bill.
Without objection.
Okay, thank you very, very much. So the debate and eventual voting on the big, beautiful bill has begun. Hallelujah. It's taken a while for us to get here, but we're going to have a debate worthy of a great country. We'll have what they think and what we think, and we're going to vote on this bill in the coming days, and I'm excited about that. I've worked a long time with my colleagues to get to where we are today, so to the American people. The debate is beginning right now regarding the big, beautiful bill, and I'll tell you why that's good news for you, but let me take a little bit of time to talk about current policy versus current law. I know everybody's on the edge of their seat at home, but here's what I would tell you about numbers and budget chairmen. I'm not the first budget chairman. There have been those who came before me. In 2008, Chairman Kent Conrad, a really nice guy from North Dakota, used a new baseline in the budget so he could get the farm bill in the budget. And Jared Gregg, really smart guy, former budget chairman, said the chairman of the budget committee declared the new baseline under a new budget. The budget chairman has a right to do that. That's what I'm doing. I'm setting the numbers. The parliamentarian said, that's my job as budget chairman. The resolution we're operating under to get us here, we voted to make that the case. So we're not doing anything sneaky. We actually voted to give me the authority to do this, and it passed. But again, I'm not the first chairman to change a baseline for different reasons. One, to get the farm bill in, and another occasion, Senator Sanders changed the baseline in 2022 when he was budget chairman under budget reconciliation to issue a budget rule allowing the numbers to change to get more money for Head Start. So Senator Sanders, as budget chairman, directed a new rule be written to get more money for Head Start. So don't tell me you've never done this before in terms of changing the baseline as budget chairman. The budget chairman under 312 sets the baseline. This has been acknowledged by Republicans and Democrats. The baseline has changed in the past based on the budget committee chairman's desire, one to get a farm bill in, and the other to change the numbers, a new rule to get Head Start spending. So this has been done before, but I'll be the first to say that what we're doing here is historic in a good way. In 2017, we passed the Trump tax cuts. They're due to expire in December. Why is that? Before I got here, current law was the way to score or implement tax policy. After 10 years, the tax cuts expired, current law. As budget chairman, I've decided to use current policy when it comes to cutting taxes. If you use current policy, they never expire. So the policies that were created in 2017 would not end in December. They would continue. And that's a good thing for the American people. That's a good thing for the economy because it gives you certainty. So I made a decision as budget chairman, working with my colleagues, to look at tax cuts, something important for the country, to give certainty to businesses and individuals and make sure after 10 years they don't arbitrarily go away and have a cliff. So I made that decision, my colleagues backed me up, and that's in the budget resolution governing the debate that we're here today. So why do we want to make the tax cuts permanent? Because if they expire in December, the average family of 4 in South Carolina will have a $1,700 increase. I don't want that, and I bet you people at home don't want that. So we have to deal with that. That cliff is coming, and not only do I want to avoid that cliff, I don't want to put us in that position ever again. So the tax cuts have generated more revenue for the government than CBO estimated in 2017. The one thing about our friends at CBO, I appreciate all your hard work, you've worked really hard. When it comes to taxing, they always get it wrong about how much revenue to be collected. So when you look at the years that have passed since 2017, on the corporate side and on the individual side, the revenue to the government has actually grown because of those tax cuts, and that's a good thing. So cutting taxes means more money for you and your family. Our friends on the other side, if you're waiting on them to cut your taxes, you're going to die waiting. So they're never going to do it. Why are we doing it? Because they won't do it. We could never get 60 votes for this. So the bottom line is we're going to make these tax cuts permanent, and that's a good thing for businesses. Expensing will be allowed so you can invest and grow in your business. You can buy new equipment. You can write it off sooner, and that will get more activity in the economy. It's not me saying that. There's a track record, Mr. President. You've been in business. This stuff works. They don't like it, but it works. If you're in business and the tax code encourages you to invest in your business, you will. This stuff literally works. And they hate it because it's money that could have gone to the government went back into the economy what they don't realize, actually, the government gets more money. They just keep spending it. And we could do better on the spending side. And we are going to do better on the spending side. So this bill makes the 2017 tax cuts permanent. It avoids a tax increase for your family that's coming in December if we don't act now. It secures the border. One of the reasons there are more of us than our Democratic friends is how you screwed the country up for the last 4 years. We went from secure borders to completely open borders, absolute chaos, and that's why we're winning and you're losing. And you want to take us back to open borders. We're not going. We're not going back to your policies that allowed 8.3 million encounters at the border, 1.7 million gotaways, chaos to cities and communities. We're not going back to the policies that led to Laken Riley's murder in Georgia, where the man convicted for murdering her was captured several times, released because there was no detention space to hold him in Texas, and he left a free man, went to Georgia and killed this lady. That's happened too many times, and it's going to stop. Now, what are we doing to secure the border? We went from lawless borders to the most secure borders in 6 months because of President Trump. President Trump, you should be exceedingly proud. Holman, the whole team, you've locked that border down, but we want to do it in a way that it'll stay locked down for the president after you and beyond. So how do we secure the gains made by President Trump and his team? We're going to, in this bill, hire more ICE agents to expedite removal of people that shouldn't be here, particularly criminal elements, people that are dangerous. We're going to finish the wall. Not one Democrat, maybe one, no way would get 60 votes to hire more ICE agents. No way we would get Democratic help to finish the wall. And we're going to go from 40,000 detention beds to 125,000. This secure the border is about $175 billion. New technology along the border, fiber cable, so we don't go back to the days of open borders. This is in the bill. To those of you who voted for us and President Trump to secure the border, we're delivering through this bill. And they would never do what we're doing. I'll be the first to admit, when it comes to securing the border, they're never going to do what we're doing. We're hiring more ICE agents, we're finishing the wall, and we're increasing more detention beds so we don't let people out that can go and murder. I'm very proud of this. I wrote this part. This is money well spent. This will secure that border in perpetuity. President Trump, this is your plan. It is in our bill. Well done. To my friends on the other side, you had your chance and you screwed it up big time, and that's why we're in charge. Revitalize our military. The world is a dangerous place. We have $150 billion in this bill to help build out the Golden Dome, to help improve the quality of life of men and women serving in the military by improving their barracks and housing. They need the money, more weapons. It's in this bill, and we didn't have to get extorted to buy a bunch of butter to get $150 billion. We reduce government spending over a decade by $1.6 trillion. We're running deficits, national debt of $37 trillion. So what have we done here? In the last to now, Medicaid has grown by 50%. So what's happened is that Medicaid was originally intended for children and poor families, children and people who were disabled and couldn't work to provide health care. Count me in for that, makes a lot of sense. Along comes President Obama. He expands Medicaid to include able-bodied adults for the first time. And what he did was he incentivized states to include these people in Medicaid. For every new able-bodied adult, you get 90% of the cost from the federal government, 10% from the states, and Medicaid has grown 50%, is going to take over Medicare because of what President Obama did. So what are we going to do? We're going to try to deal with that in a responsible way. What about this idea? If you're not a child, if you're not disabled, you're able-bodied, and you don't have any children under 14, we're going to have a 20-hour-a-week work requirement for you to stay on Medicaid. That's a good thing. It's a good thing for the individual involved to be working. It's a good thing for the taxpayer for them to be working. But that seems to be a crime on the other side, to ask somebody to work that can work. How many people out there are listening to this? I don't know how many you are, but are you working every day? Are you going to work with kids? A lot of people do that, by the way. So one of the reforms in this bill is to introduce a work requirement to the additional population that President Obama put on Medicaid that was never intended on the original purpose of Medicaid. This work requirement is going to save a bunch of money. Finally, we're addressing the biggest scam I've seen in a very long time. Somewhere along the line, somebody figured out that at the state level, that if you tax doctors and hospitals and medical providers on the funds they get and take that revenue, you can actually get more Medicaid money. This is a money laundering scheme. It needs to come to an end as we know it. States have gone up to 6% of a provider tax. They take that tax revenue and they use it to get more money from the federal government. The hospitals and doctors don't lose, they get the money back. The state doesn't lose, they get more money. The only group that loses is the federal government, and we're deep, deep in debt. So we're going to reform the provider tax system that I think is abusive, very abusive. As to Medicaid, it's on a growth trajectory that will overtake Medicare. Now is the time to put common sense reform in place, not only to slow the growth, and we're not talking about cutting Medicaid, we're slowing the growth, but try to create some sense of fiscal responsibility. So to our chairman of the Finance Committee, you have constructed a package better than 2017. You have included some growth elements in the package that will allow the economy to grow because it will be in businesses' interest to invest. And I want to applaud you for this growth package. Now, what does this all mean? Current policy, current law. If you do what I have decided to do, make the tax cuts permanent, and you implement these reforms to Medicaid and other areas, you will, over the next 10 years, reduce the deficit by $507 billion. That's CBO, not me. Now, how do you do that? You grow the economy, and you begin to control spending in a common sense way. Most people can relate to that because they do it all the time. People at home sometimes have to work extra to meet the needs of their family, and they have to tighten their belt. So what have we achieved here in the one big beautiful bill? We're going to make your border as secure as it possibly can be and never go back to open borders. We're going to put in place border security measures to keep it secure. We're going to make the tax cuts permanent so your taxes do not go up in December of this year, and we're going to add additional pro-growth policies to help our economy. We're going to reform Medicaid in a way that makes sense, deal with the waste, fraud, and abuse of that program so that there's more money for the disabled and children, because the more money you give the able-bodied who can work, it's less money for children and people on disability. And one of the most perverse things about what President Obama did is that the reimbursement rates to states are higher for able-bodied adults than they are for disabled people and children, 90%. So President Obama created a system to entice states, lure them in to add people to Medicaid that are not disabled, not poor children, because his goal was to put everybody in the country under government-run health care, and the government reimbursement is higher for an able-bodied person than it is for a poor child or a disabled person. And we're going to stop that, because that's not fair. It's not fair to the taxpayer, and it's not fair to the population that we're trying to help. So we're going to control spending in a common-sense way. We're going to revitalize our military at a time of great need. We're going to secure the border, and we're going to make the tax cuts that expire in December permanent, so we don't have to deal with this every 10 years. It's a big, beautiful bill if you believe in cutting people's taxes, securing the border, having a strong military, and controlling government spending. It is a nightmare, this bill, for those who want to raise taxes, who want open borders, who want a weak military, and never want to control one dime of federal spending. This bill is your nightmare if you're for open borders. This bill is your nightmare if you want the government to grow without any limitation. This bill is your nightmare if you want a weak military, because it's going to give us a stronger military. So why do we have this debate? That's what they, through years of effort, have done. The military is always the last thing that gets funded when they're in charge. When they're in charge, you have no border. Completely broken, millions of people running through our country, lawless. When they're in charge, there is no limit to growing the government. They entice everybody to grow the government. And when they're in charge, they're never going to cut your taxes in any meaningful way. The tax rates since 2017, the top rate has been 37. If these tax cuts expire, your taxes, if you're a family of four, will go up by $1,700. And we'll go back to the 39.6 rate. Here's a question for the country. How much should the federal government take of anybody's income? What's a fair share? 37% seems pretty damn fair to me. Over a third of what you make, and that doesn't count state and local taxes. The number they would pick is probably a 90. So is 37% fair? I think yes. Most Americans think 25% is fair. You know, Jesus wants 10%. There is no number they won't embrace. So somewhere between 90 and 10, 37 is fair. This is not rewarding the wealthy, it's creating a number that makes sense. 37% going to the federal government is a fair share. It's over a third of what you make. And that doesn't count state and local taxes. This has been long, it's been hard, but we're about done. In a couple of days, we're going to pass the one big, beautiful bill. President Trump's going to sign it. Mike Crapo and his staff deserve at least one day off. I cannot thank you enough for what you and your team have done. To my budgeteers, you have been terrific. You've worked really hard to CBO and joint tax and all these people. Hats off to your efforts to get us a quality product. To all of my colleagues who've rowed the boat with us, we're about to reach the shore. And when this boat comes ashore, every family in America can have a sigh of relief. Your taxes will not go up this December. You'll get a Christmas present of not having a tax increase. To those who've been yearning for a secure border, it will be secure. To those men and women in uniform, you're going to get some help and you desperately need it. And to those who think we should do something about the government's growth in a common sense way, we've achieved that. I am very proud of this bill. I'm very proud of President Trump. I'm very proud of the Republican team that has gotten us to this point. And to my Democratic colleagues, we'll work together where we can, but nobody over here ever expects you to do anything about the border, because you've proven you can't. Nobody over here believes you're ever going to reduce the size of government, because you don't want to. So the bottom line is, we're about to make history, Mr. President. This is your first term. I don't know what comes later for you. I hope you're here a long time, if that's what you want to be. You're a great senator. You're a good businessman. You've made a real success story. Family from Colombia. You've created a lot of job opportunity. I doubt if you'll ever do anything more important than this. Senator Crapo, you've been here a while. You're one of the smartest guys I ever met. Everything you've done all your life has led to this moment. This is what you were built to do. This is what you were meant to do. You're the right man at the right time to do what this country desperately needs to stay on track to be safe and prosperous. To all my colleagues who are going to vote for this bill, you should be proud, and you should talk about it, because it's going to make us all safer and it's going to make us all more prosperous. Me being budget chairman is a quirk in the history of the Senate. This is not my thing normally, but I have really gotten into it, and I've learned a lot thanks to my colleagues, and I'm proud to have the honor of being budget chairman at a time I think it matters the most. Mr. President, I ask unanimous consent that the following staff members from my staff and from Senator Merkley's staff be given all access floor passes for the consideration of the bill. Caitlin Wilson, Lillian Meadows, Scott Graber, Walker Turlock, Taylor Reedy, Democratic staff Mike Jones, Melissa Pistner, Josh Smith, and Tyler Evilsizer. Tyler, Evilsizer. I ask that unanimous consent.
Without objection.
With that, I will yield to my good friend from Idaho.
There's one more behind it.
Huh?
Behind that.
Oh, wait a minute.
Nope.
That the use of calculators, whatever they are, be permitted on the floor of the Senate during consideration of the bill.
Without objection.
Mr. President.
I recognize the senator from Idaho.
Thank you, Mr. President. And first of all, let me thank my colleague from South Carolina, Senator Graham, for his very kind words. I return the same kind of compliments to him for his great work in helping to build this bill and get us moved to this point. I'm going to make just a few remarks right now in response to some of the allegations and myself. But the things that were said this morning just have to be responded to. First of all, it is said that the reason that we are going to increase the debt ceiling in the bill is because we are spending so much money and driving the deficit up. Well, first of all, our bill drives the deficit down, not up. And secondly, the reason we are dealing with the debt ceiling in the bill is because under the previous administration's operations, the debt ceiling has already been breached. It was breached on January 2nd. And we are limping along with extraordinary measures, is what we call them here in Washington, to try to keep the government funded until Congress can extend the debt ceiling. This has nothing to do with President Trump. It happened before he even was sworn into office. It has nothing to do with this bill.
it has to do with the profligate spending that drove us into a breach of the debt ceiling on January 2. Secondly, my colleagues on the other side tried to characterize our choice of the current policy baseline as a gimmick and said it's never been done before. Well, they should have been more careful in their words, because the current policy baseline is currently utilized in the current CBO baseline for many spending programs. In fact, many spending programs, about $2.5 trillion of spending programs, are measured under the current treatment, which the Democrats have been using for decades, to make it so they don't have to count spending increases as an increase in the deficit. They are correct that that policy has never been applied to taxes before, because it was not intended to apply to taxes. That ruling and that system that was set up was intentionally designed to favor tax increases over spending cuts, and to force Congress to increase taxes and increase spending. It was a strategy to achieve what we all know of as tax and spend. And no matter how they try to cover it over today in their debate, it comes down to this: they are furious that we refuse to raise taxes in America by $4.3 trillion on Americans. And they claim that our refusal to raise your taxes, America, is going to run up the deficit because they can't get $4 trillion more of your tax revenue into their pockets. Well, the first failure of that rationale is, if you believe that you give them $4.5 trillion by letting them raise your taxes again, let me tell you, there's not a tax increase that I've seen in this Congress in my lifetime that was used to pay the debt down. It was used to increase spending. It's called tax and spend. And it's that bias in our scoring system that we are fixing today. We are fixing it so that current policy is how you treat taxes, just like you treat $2.5 trillion of spending this year in your scoring system. We're evening the balance board between taxing and spending. And America should sigh a sigh of relief that finally we are fixing our scoring procedures so that we don't have a built-in drive to increase taxes. Let's put it another way. One of my colleagues said, just even children can understand the difference between $1 trillion and $0. I think they can also understand that if you don't raise taxes, you're not changing the tax code. You're making it bring in the same revenue that it brought in before. You're not increasing the deficit, you're protecting their wallets. And the bottom line here is very simple. I think every American, at least 90% of them, intuitively understand that the refusal to let your taxes go up by $4 trillion is not a deficit increase. You are not the responsible. Us keeping your money in your pocket is not making you responsible for increasing the deficit. Deficit increases come when Congress keeps spending your money and never, ever controlling its spending. The problem is not a lack of revenue. It is too much spending. So let's make it clear. This is not a gimmick. The gimmick is the one that's been used for all these years. We are making a balance between the treatment of tax and spend so that those taxpayers in America have at least a fair chance against the rules of this chamber. Now, one other thing that I think needs to be made here is there was a lot of talk on the other side, and then I'll stop and bring my longer speech later. One other point that needs to be made here is that it was suggested that this has never been done before, even on taxes. Well, there's a president named President Obama who faced a similar situation like we face today. Only then he was president when a huge tax cut that President Bush had accomplished was expiring. And all of those tax cuts that President Bush had been able to achieve were going to go away, and everybody's taxes were going to go up. And President Obama said, no, I'm not going to let that happen. So he put a bill out on the floor to stop those tax increases from happening. And he was attacked, actually, for increasing the deficit by not letting taxes go up. And President Obama, through his OMB deputy director, said that keeping tax policy current should be scored under a current policy. And that if his act in letting those tax increases be kept in place should be scored as current policy, not as a tax increase. So you've got one of your own presidents from the Democratic Party saying that letting existing tax law stay in place and protecting against huge tax increases on the American people is the appropriate approach to take. That current policy, and those are their words, current policy is the way we should treat tax policy. So I say to everybody in America who's been hearing all of the politics of fear about what we're doing here and running up the deficit, need to remember that only in Washington, D.C. is the refusal to raise your taxes an increase in the deficit. And we're not going to let that happen. Thank you very much, Mr. President. I yield the floor.
If no one yields time, time will be charged equally to both sides.
Mr. President.
I recognize the senator from Michigan.
Mr. President, I rise today in opposition to a widely irresponsible legislation that is before us now. Although our colleagues are calling it the big, beautiful bill, this bill would instead be a betrayal to our economic future, hardworking American families, and some of our most vulnerable seniors, children, and people with disabilities. This bill will blow up our national debt, kick millions of people off of their health care, and take food off of families' tables while cutting food assistance. And for what? What our colleagues are mortgaging our country's future for? What are they slashing health care and food assistance to pay for? Well, they're doing it for tax cuts for billionaires. So before my colleagues rush to pass this irresponsible, reckless legislation, let's take a moment to go through exactly how much harm this bill will actually cause and hear from the people in my state who are going to suffer if this law becomes law. To start, this bill will blow up the national debt. Since President George Washington gave his farewell address, our nation's leaders have warned against the dangers of accumulating a national debt. 15 years ago, Admiral Mike Mullen, former chairman of the Joint Chiefs of Staff, stated, quote, "The most significant threat to our national security is our debt." The national debt is at an all-time high, $36.2 trillion. And just in the last 16 years, it has tripled. Our annual deficits frequently exceed $1.5 trillion, including a record $3.1 trillion deficit in fiscal year 2020 during the Trump administration. Unfortunately, these are the first of many grave financial milestones that we face. Within the next decade, our country will spend more on servicing the debt than we do on any other federal account outside of Social Security. Our fiscal house is basically on fire. But if our Republican colleagues jam through this bill, it's not going to pour water on that fire, it's going to pour gasoline on those flames. Democrats have tried to make efforts to pay down that debt in recent years. In fact, under the Inflation Reduction Act, a law that this bill attempts to actually gut, we reduced the deficit in that bill by nearly $250 billion. And in 2023, we passed the Bipartisan Fiscal Responsibility Act, which responsibly addressed the debt ceiling and had the potential to reduce deficits by up to $1.5 trillion. But unfortunately, the bill before us basically wipes all of that away. And I have always said that I'm open to making smart cuts to spending, but that those cuts should be matched with increases in revenues. Doing so would put us back on a sustainable financial path. Our Republican colleagues are doing the exact opposite. They're making drastic cuts to revenue, and according to the nonpartisan Joint Committee on Taxation, the tax provisions in this bill alone would decrease revenues by $4.2 trillion and add $3 trillion to our national debt. This is a recipe for disaster. If we face another emergency, like a pandemic or global financial crisis, we will be too hamstrung by our debt to respond effectively. We are on the brink of a financial disaster, and passing this bill could push us over that edge. Also, my Republican colleagues can cut taxes for billionaires. At the same time, our Republican colleagues are not making smart, sensible spending cuts to cover the costs that these billionaire tax cuts will mean. Instead, they're gutting health care for millions of Americans, including hundreds of thousands of Michiganders. It's reckless, and it is wrong. Medicaid is a lifeline for people in every single community across this country. It ensures that millions of Michiganders and Americans can have access to quality, affordable health care. And right now, folks across my home state of Michigan are scared. Scared about what this bill will mean for their families. I've heard from thousands of my constituents from every corner of the state of Michigan on how these cuts are going to hurt them. So today, I just want to tell you, through my constituent stories, just how detrimental this bill will be for most Americans. Take Isaac from Lansing, for example, who says Medicaid is the only lifeline he has to pay for the medicine that literally keeps him alive. We've also seen how more and more Michiganders and people all across our nation have shouldered the burden of serving as a primary caregiver for an aging parent. It's the ultimate gift that we can give to the people who have raised us. But the cost of critical nursing home and assisted living care continues to rise. Medicaid has become an essential way for our aging seniors to pay for the care that they need. Take Gwen from Grand Rapids, who says she wouldn't be able to pay for an assisted living facility for her grandmother without Medicaid. Many of us know someone, or maybe even love someone, who lives with a disability. Thanks to Medicaid, people with disabilities can get the care that allows them to live healthy and independent lives. That is the case for Wanda from Westland, who takes medication for an eye condition. Without Medicaid, she would not be able to afford her medication, and she could actually go blind. As too many of us know from personal experiences or from friends and loved ones, our country is facing a mental health crisis. Medicaid has become a saving grace for those who desperately need mental health care, but simply cannot afford it. Take Alan from Fort Gratiot, who says losing Medicaid would feel like losing the lives he's been given back through mental health care from Medicaid. Under this bill, rural communities will be especially impacted by cuts to Medicaid. In some counties in Michigan's Upper Peninsula, there's only one health care provider, meaning some Michiganders will have to travel up to 50 miles to get routine or emergency care. Medicaid helps keep these hospitals open. And if this bill passes, people in these rural communities are going to be cut off from basic health services. Medicaid also plays an essential role in making sure that children across Michigan get the care that they need. I heard from Gladys, a mother from Flint, who says Medicaid is the only reason her kids can get their asthma medication or have regular health checkups. Expecting mothers also reached out to share their concerns. While she is busy preparing to welcome a newborn baby into the world, Chelsea from Fenville is now afraid that she will lose her access to both pre- and post-natal care under this absolutely disastrous bill. I simply can't understand how my Republican colleagues would leave thousands of people across Michigan without the care that they need, all so they can give a tax break to billionaires. On top of that, my Republican colleagues are also proposing deep, harmful cuts to food assistance delivered through SNAP. SNAP serves as an absolute lifeline for millions of Americans, including children, seniors, people with disabilities, and working families. So simply put, if this bill is passed, it will mean people in Michigan and all across our country will go hungry. They will not be able to put food on the table while billionaires pay less taxes. That is just wrong. But it also makes no economic sense either. Every dollar in SNAP benefits generates more than $1.50 in economic activity. This supports local grocery stores, farmers all across our country, and the entire food supply chain. So on top of jeopardizing families' ability to put food on the table, to feed their children, these proposed SNAP cuts would also hurt businesses and jobs, particularly in rural America and in low-income areas. This bill produces the most amount of pain for the least amount of gain of any legislation that I can remember in all the years that I've had the privilege of serving here in the Senate. Mr. President, I can't believe that we are standing here debating this reckless irresponsible bill. The harm this bill will do to the American people and to the people in my state of Michigan who are counting on Medicaid for health care and on food assistance to help feed their families is absolutely reprehensible. The damage this bill will do to our nation's economic security is not only reckless, it is unconscionable. This is not what our constituents want us to be focused on. They want us to help make their life better. But instead of focusing on that, here we are on the brink of passing a bill so irresponsible that it will destroy our country's economic health, harm millions of Americans, all so a handful of billionaires, the wealthiest of the wealthy, can have another tax break. Mr. President, I will never support such a reckless and catastrophic plan. Mr. President, I yield the floor. No, this is.
Mr. President.
I recognize the senator from Idaho.
Thank you, Mr. President. You get to be here for my second speech. I'm here to talk now about the centerpiece of this reconciliation bill, making the 2017 tax cuts permanent. The One Big Beautiful Bill prevents the largest tax hike in history and provides groundbreaking new tax relief for middle-class workers and families. This legislation permanently extends the Trump tax cuts, which proportionally benefited the middle class the most. If these tax cuts were allowed to expire, taxpayers in all income groups would see massive tax hikes. And a point that my colleagues on the other side seem to consistently forget or ignore is that the vast majority of them, $2.6 trillion worth of those tax cuts or tax increases, would fall on taxpayers making less than $400,000 per year. And the vast majority of that is on taxpayers making and earning in the middle and lower middle income categories. No, hold on that one. But before I go on to discuss what would happen, I want to address an issue that is just a constant theme on the other side, and that is that this bill is going to be a huge increase in the deficit. Now here's a quick handwritten chart that my colleague from South Carolina made quickly to respond to them. You heard the previous speaker say that CBO has scored this bill to have a huge multi-trillion-dollar deficit increase. The fact is that CBO has scored this bill to have a $507 billion deficit reduction. You heard that right, a $507 billion deficit reduction. And later on in my remarks, I will point out that that score doesn't even take into account the growth in the economy and the revenue that will come to our Treasury from revitalizing and giving a boost to our economy. So now let's go to the next chart. What will happen if we don't do this? What will happen if we do what the Democrats are demanding that we do? And that is to let this tax increase happen so that they can say they're going to use it to pay the deficit down. The average family of four would see a tax hike of $1,700 and their child tax credit would be cut in half. 20 million small business owners would face massive tax hikes, with some of them facing rates as high as 43%. The standard deduction, which simplifies tax filing for 90% of Americans, would be cut in half. Small businesses and farms would see their death exemption cut in half. The Council of Economic Advisors warns us that this $4 trillion tax hike would also lead to an economic downturn and potential recessionary headwinds, noting that the impacts would disproportionately fall on young people, minorities, and workers without college degrees. We've been working for more than a year on legislation that prevents that outcome and provides an opportunity for us to have additional tax relief that is specifically targeted to benefit low and middle income families and workers. Despite the rhetoric of fear, our critics' rhetoric about tax cut as being for billionaires and corporations, the reality of this legislation prevents a massive tax hike across the board and overwhelmingly benefits middle-class households and job creators. According to the Joint Committee on Taxation, this bill provides more than $600 billion, that's $600 billion more of new tax relief for hardworking Americans. How does it do that? $73 billion in inflation tax relief targeted at income brackets below $100,000 per year. $205 billion in tax relief to the 90% of taxpayers who claim the standard deduction. $93 billion in additional tax relief for seniors through a $6,000 bonus exemption. $124 billion investment in children of low and middle income families, in addition to the permanent doubled child tax credit. I'm going to say that again. The permanent doubled child tax credit. The significant tax relief we are providing to hardworking families includes permanent lower tax rates, letting Americans keep more of their hard-earned money, permanent increased and enhanced standard deduction, claimed by over 90% of taxpayers. On top of making that doubled child tax credit permanent, we are also increasing it for tens of millions of families. Tax relief for seniors in the form of a $6,000 bonus exemption for low and middle income seniors, slashing their tax burden. No tax on tips for millions of tipped workers like waitresses, barbers, hairstylists, and taxi drivers. No tax on overtime for millions of America's hourly workers who work overtime and keep America running. No tax on auto loan interest for new cars made in the United States, allowing the hardworking families of America to fully deduct auto loan interest on American-made cars. Enhanced 529 education savings accounts, making education expenses more affordable and accessible for families. New Trump savings accounts for newborns and children set up to the age of 18, building financial security for the next generation. We make child care more accessible and affordable for working families by enhancing the Child and Dependent Care Credit and the Dependent Care Assistance Program. The list goes on and on. We extend the paid family and medical leave credit and expand health savings and accounts for health care expenses. We repeal onerous IRS reporting requirements on gig workers, reduce the paperwork burden for small businesses, and much more. And all of this just on the individual side of the code. The business side of the tax code has the potential to generate phenomenal economic growth. When my Republican colleagues and I began talking about how to best extend and enhance the Tax Cuts and Jobs Act, we agreed that one of our top priorities was to make it permanent. The reforms we made in 2017, including lower rates for corporations and small business owners, along with the international tax reforms, increased domestic investment, boosted economic growth, and increased take-home pay. A growing economy powered a strong labor market. Workers saw record wage growth, and the unemployment rate fell dramatically to the lowest in 50 years at 3.5%. Corporate inversions, which we used to debate endlessly, or businesses leaving America, became a thing of the past. They literally ended. And America became the place to do business again. Capital making them permanent is a key to driving additional growth and investment in the United States. For businesses that spur investment and economic activity across the country, this bill makes the 20% small business deduction permanent, enabling job creation and spurring local economic activity. Restores and makes permanent full expensing for domestic research and development, encouraging domestic innovation. Restores and makes permanent full expensing for new capital investments, like machinery and equipment, boosting domestic production. Restores and makes permanent interest deductibility, helping to finance critical domestic investments and keep America globally competitive. It includes full expensing for new factories and factory improvements to accelerate domestic manufacturing. Permanently renews and enhances the Opportunity Zone program, driving $100+ billion of investment to rural and distressed communities. According to the Tax Foundation, permanence for the bill's 4 cost recovery provisions I've just reviewed would more than double the long-run economic effect. The National Association of Manufacturers predicts $248 billion in economic growth will come from the manufacturing sector alone, along with over 1 million jobs and over $100 billion in new wages. The National Federation of Independent Businesses says that making the small business deduction permanent will create 1.2 million jobs over 10 years, growing to 2.4 million jobs in the long run. That growth also means more federal revenue created right along the way. And the Council of Economic Advisors estimates that the tax legislation alone, this tax legislation alone, will drive more than $2 trillion in offsetting deficit reduction, thanks to permanent provisions that power economic growth and incentivize investment. Over a 10-year window, with this legislation in effect, the Council of Economic Advisors estimates that debt as a share of GDP will fall to 94%, compared to 117% if the Trump tax cuts expire. And this chart is important to look at. This is what happens to our deficit if we pass this tax legislation and grow our economy. And this is what happens if we don't. The red line is what happens if we don't. Over a 10-year window with this legislation in effect, as this chart shows, the estimate is 94% compared to 117% if the Trump tax cuts expire. So while my colleagues on the other side complain and complain that we will not let taxes go up, this is what will happen if they do go up. Far from adding to the deficit, this legislation will finally put us on a sound financial footing as we power growth and curb spending. For those who claim that this bill will add over $4 trillion to the deficit, it bears repeating. Preventing a $4 trillion tax hike is not the same as deficit spending. And those who say that we should let a $4 trillion tax hike go into effect to pay down the national debt, every tax increase that Congress has adopted for as long as I can remember was not used to pay down the national debt. It was used to increase spending. And that's exactly what is going to happen if the Democrats have their way and force this tax hike to happen. It was used by Congress to spend more money, not to reduce debt. Extending current tax policy means that tax revenue as a percent of GDP will remain relatively unchanged. We do not have a revenue problem in America. We have a spending problem. That's why we asked JCT to score this legislation under a more realistic scenario using a current policy baseline. The Council of Economic Advisors estimates that making the Trump tax cuts permanent, combined with other Trump administration pro-growth policies like regulatory reform and so forth, it will increase federal revenues by more than $4 trillion, far more than offsetting any deficit estimates. When combined with the $1.6 trillion in spending reductions, this bill represents historic savings for taxpayers, far exceeding the spending reductions in the past by hundreds of billions of dollars. And I want to look at this chart. I've talked a lot about tax cuts and protecting against tax increases and economic growth that happens from that. But reducing spending is another critical priority that we must address. And in addition to the pro-growth tax policy that I've just described, we cut spending by $1.6 trillion. This chart shows how other bills have tried to take a shot at reducing spending in the past. We far exceed any spending reduction bill that Congress has ever passed. We're paying attention to the revenue side, and we're paying attention to the spending side. To achieve this record level of savings, we are slashing President Biden's Green New Deal spending and promoting an America First energy policy. We are eliminating hundreds of billions of dollars of the Green New Deal subsidies, including ending wasteful credits like the EV tax credit. We stopped penalizing fossil fuels in favor of unreliable and expensive green energy, and instead support consistent energy sources, making energy affordable again. We are also rooting out waste, fraud, and abuse in federal spending programs, as my colleague from South Carolina mentioned, like those that we have identified in Medicaid. This will not reduce benefits for those who are qualified and for whom Medicaid was intended. It will reduce waste, fraud, and abusive scams that are being used to get the American taxpayer to funnel money into states or into other programs. This program was created to help pregnant women, children, and seniors in America and those with disabilities. We are continuing to protect them. They will not lose benefits, and the politics of fear that you hear constantly are simply false. But in recent years, the Democrats have incentivized Medicaid to enroll healthy Americans and illegal immigrants, driving up taxpayers and risking the program's sustainability for those who need it the most. This is what has happened. This is what's happening to the enrollment and the spending in Medicaid. The fate of this expansion is an unsustainable path and puts the future of the program at risk, including the United States federal debt. As spending has surged, so have inappropriate payments and ineligible enrollments, along with gimmicks and loopholes. People are alarmed by these statistics, but official reports indicate that the federal government made $543 billion in inappropriate Medicaid payments from 2015 through 2024. Some experts think that that number is closer to $1 trillion. That is what we are addressing in this legislation. We have the responsibility to ensure that programs like Medicaid work efficiently and effectively and remain financially viable for those for whom it was designed to help. For months, my Democrat colleagues have engaged in the politics of fear, warning that Republicans are going to rip this critical program from those most in need. Let me be clear. This legislation does not take Medicaid away from any recipients for whom the program was designed to help. Children, the elderly, the disabled or infirm, adults caring for children, and elderly relatives are protected by this bill. We would not be honoring our obligation to these recipients if we allow the program to continue to balloon, forcing vulnerable populations to compete for available resources with able-bodied adults who refuse to work. As one father recently wrote in the Wall Street Journal, Medicaid was created to help people like my son. He is 17, has severe autism and epilepsy, and needs constant attention. Yet thanks to Obamacare's Medicaid expansion, he is stuck on a multi-year waiting list for an in-home care, because able-bodied adults are competing for the same results. CBO estimates that over 1.4 million illegal aliens are receiving Medicaid benefits. I'm talking about those who are not United States citizens and are not legally in the United States, receiving Medicaid benefits, and pushing those like this man's 17-year-old son out of his opportunity to get access to those benefits. Brett Guthrie, the chairman of the Energy and Commerce Committee in the House, correctly notes, every dollar misspent on illegal immigrants and ineligible individuals in the Medicaid program means less money going to our children, our pregnant women and mothers, individuals, and others who are disabled and seniors. Republicans are committed to preserving and strengthening Medicaid for the people Medicaid was intended to serve. That starts with making common sense reforms to eliminate waste, fraud, and abuse in the program. This bill targets rampant fraud in the program by removing illegal aliens, deceased recipients, or those enrolled in multiple states. It eliminates wasteful spending by ensuring that Medicaid payments align with levels in Medicare and other spending programs, and increases the frequency of eligibility checks. It requires more personal accountability and promotes pathways to work for able-bodied adults. The work requirements proposed in this legislation are simple. Many people are amazed that they're so easy to meet and yet so rigorously opposed. If you are an able-bodied adult without dependents, you can qualify for taxpayer-funded Medicaid by spending 20 hours per week working or participating in work training or going to school or participating in community service or volunteer work. The majority of Americans agree that these rules are responsible guardrails to protect a program that was designed to protect America's most vulnerable Americans. The bill also corrects abusive practices by freezing and reducing provider taxes, a financial gimmick used by states to increase federal spending that they receive. For those concerned about funding for rural hospitals during the transition back to responsible funding levels, the legislation creates a bridge funding system to help stabilize rural hospitals and enhance their long-term financial solvency. And while Democrats claim Republicans are slashing Medicaid spending, the reality is that even with these reforms, Medicaid spending is projected to continue to grow by billions of dollars over the next 10 years. Only in Washington is a smaller increase in spending considered a cut. In reality, these reforms will improve, protect, and preserve Medicaid for the most vulnerable Americans. We've had a very robust debate over how to best deliver on President Trump's agenda, and I'm proud of what we achieved in this legislation. The tax provisions in our bill, from permanent extension of the lower tax rate to the increased child tax credit to the permanent tax relief for businesses, will deliver financial security for American families and grow our economy. The health care provisions will protect and preserve Medicaid for the Americans that the program was designed to serve. And while more work remains, this bill's economic growth, combined with deficit reduction that we have in it, finally puts our country on a much better fiscal trajectory. Speaking of work, I would be remiss if I did not take a moment to thank the excellent staff from the Joint Committee on Taxation, the Congressional Budget Office, and the Senate Legislative Council for the hard work and countless hours they have put in to get us to this point. Some of them have been working with us on these provisions for years, and we greatly appreciate your partnership in this effort. I ask unanimous consent to have these individuals' names printed in the record. Thank you. I also have to thank my incredible staff who have foregone sleep over the past several months to provide timely, indispensable insight, facts, legislative text, counsel, and so much more. Without them, we would not be at this point and ready to deliver this much needed growth-focused policy for the American people. I ask unanimous consent to have the names of my entire Finance Committee staff printed in the record.
Without objection.
Thank you. Even with all that, and all that we accomplish in this legislation, there are dozens of additional good ideas, smart policies, and common sense reforms that we were not able to include today. And I commit to working with my colleagues to advance those goals as well as we move forward. But today's historic legislation is more than a good start and will pay dividends for American families, extending good tax policy, delivering targeted relief, and reining in wasteful spending as achieved in this bill is the best way to restore economic prosperity and opportunity for all Americans. I look forward to getting it to the President's desk as soon as possible. Thank you, Mr. President.
Mr. President.
I recognize it. Democrat Whip.
Mr. President, we're here today debating a clumsily assembled package, still a work in progress, that would rip away health care from 16 million American families to give tax breaks to millionaires, billionaires, and our largest corporations. Think about that for a moment. The Republicans have decided that the best avenue to generate revenue that they can then give in tax breaks to wealthy people is to eliminate health insurance coverage for 16 million Americans. That's going to have a dramatic impact on their lives. If you have ever been a young father with a baby with a serious medical problem and you had no health insurance, you'll never forget it as long as you live. I know, I've been there. The notion of losing your health insurance leaves you as vulnerable as possible in some of the most important moments of your life. And that they would consider this provision to eliminate health insurance coverage for 16 million families is cruel. Let's not act like there is a unified Republican front on this issue. Even some of my colleagues on the other side of the aisle don't want to be here at this moment, jamming this unpopular bill through this chamber under arbitrary deadlines. One of my colleagues took a look at tax breaks, and you're going to hear them say over and over again, well, the average family, if we don't act, the average family is going to have to pay more in taxes. There's a way around that. If we limit any tax breaks in this bill, in this effort, to people making $400,000 a year or less, $400,000 a year or less, it virtually eliminates 2/3 of the cost of this undertaking. And it means you don't have to take away the health insurance of 16 million families. So there are ways to do tax breaks which make sense. Count this Democrat in with the Republicans for helping working families who are struggling to get by, and a lot of them are, living paycheck to paycheck. And the notion that we would say to them, we're going to take away your health insurance, we're going to raise the cost of health insurance for you, is no answer to their problems. Behind closed doors, my Republican colleagues continue to be consumed with infighting, bickering over the bill's substance, and for good reason. We have a process here which is almost impossible to explain to an ordinary person of how we reach reconciliation. The parliamentarian's office, and she's sitting here, God bless you for what you've been through for the last several months, and all your staff, have to make decisions on a daily basis over and over again as to whether or not provisions of this bill are eligible under the law that governs the United States Senate. We're in the process of debating this on the Senate floor. I see our ranking member on the Budget Committee, Senate Budget Committee, the senator from Oregon. We're in the process of still appealing to the parliamentarian's office on provisions in the bill. This is truly a work in progress. I think what they do know is troubling, and it should be. This bill would be a disaster for hospitals. The Senate Republican bill, unfortunately, is going to endanger hospitals all over the United States. But if you happen to live in a small town, rural area, and I represent a lot of them in the state of Illinois, you're the most vulnerable. You are the target. When they cut back on Medicaid programs, these are the hospitals that will close their doors. What's the impact of a hospital closing its door in a downstate community in Illinois? Devastating. Hospitals are not only the center for emergency medical care, good doctors, nurses, and such, they are also a major economic force in small-town America. Take away a hospital and then try to attract a new business to your community. Good luck. This Senate bill cripples one of the main ways that states fund their Medicaid programs and keep hospitals afloat, especially rural and low-income areas. It's called the provider tax. Earlier this week, a Republican senator, circulated a flyer to his fellow caucus members, so they're all on notice, detailing just how much each state will lose in Medicaid provider tax funding under their proposal. Let's take a look at my neck of the woods, the Midwest. Iowa would lose $4.1 billion. Missouri, $6.1 billion. Kentucky, $12 billion. Louisiana would lose $20 billion. North Carolina, $38.9 billion. Senator Tillis and I were in conversation yesterday, and he used that very same figure. His analysis says that to go forward with this bill cuts Medicaid reimbursement in his home state of North Carolina by a whopping $38.9 billion. This list of states and what they will lose was passed around by a Republican senator to his own caucus. They know what they're up against here. If Republicans have their way and pass this bill, hospitals will be forced to shrink or eliminate services. In Decatur, Illinois, one of the major hospitals facing the crunch time had to make a decision whether they keep their doors open. They did, but they eliminated OBGYN, delivering babies, and they eliminated all mental health and addiction counseling, two critical areas for the hospitals. So these doctors, this bill will force hospitals to shrink or eliminate services. Doctors and nurses will leave, and in some cases, the hospital will close. Imagine that in a rural area, a remote area, an extra 45 minutes, an extra hour in the car with somebody in the front seat you love very much who's in a desperate situation. As it stands today, half of the rural hospitals around the country already operate in a danger zone. And it's the same thing for children's hospitals. Do you have one in your community that you've used? I do. These children's hospitals have warned us they can't keep their doors open if Medicaid is cut as dramatically as the Republicans want to cut it. If Republicans have their way, we're going to see massive layoffs, fewer nurses, technicians, and doctors, along with decreasing quality of care. The American Hospital Association has estimated how these cuts to Medicaid could impact not just jobs at red state hospitals, but across the entire economy. Here's what they found. If the Republican provision goes through that cuts Medicaid reimbursement in order to provide tax breaks for wealthy people, Maine, as an example, one state, would lose 5,000 jobs. Kansas, 6,200 jobs. Iowa, 11,000 jobs. Missouri, 26,600 jobs. I've talked to the administrator of BJC in St. Louis, Missouri. The reason is it's not just a Missouri hospital. They have their facilities on the Illinois side of the river. In fact, 1/3 of their patients are from Illinois, and 1/3 of their patients overall use Medicaid to go to their hospital. So he's told me what's going to happen if the Republican measure goes through and the cutbacks to these hospitals. They came up with, incidentally, the rescue fund to solve the political problem. I want to check and make sure Senator Murray can back me up on this. Our overall cut in Medicaid now is about $1 trillion. Correct. $1 trillion. Imagine, this is Washington, we talk in those terms. Cutting Medicaid nationwide $1 trillion. And the rescue plan for the small hospitals that are in danger, the ones I've talked about, $1 trillion cut. How big's the rescue plan? $25 billion. Do the math. It's a joke. It is a joke. If Republican leaders think this is an adequate amount to alleviate pain all of our nation's rural hospitals are going to feel, then that's like trying to put out a forest fire with a garden hose. This simply won't work. I want to conclude by saying this. We passed the Affordable Care Act 15 years ago. Of all the things that I've worked on in Congress, I think it had more positive impact to help the families across America than anything. We found a way to make health insurance more affordable for families 15 years ago. And to do it, we held hearings, 100 hearings on the Affordable Care Act. Obamacare is what they called it. Roundtables, walkthroughs. 2 committees spent a combined 21 days holding markups so that everyone could offer an amendment. Do you know how many amendments were made to the Obamacare program? 400. 400 votes in committee and on the floor on amendments. 147 Republican amendments were included, though not a single Republican senator ended up supporting Obamacare when it was all over. What do we have here with this measure? At the end of the day, that legislation, the Obamacare, allowed more than 40 million Americans to gain health insurance. Today, how many hearings have we had on the bill that's before us, this dramatic multi-trillion-dollar bill? None. 0. Not a single one. 0 markups for senators to offer amendments. 400 amendments on Obamacare. None on this one until it comes to the floor today. 0 bipartisan input. Our friends on the Republican side have said, it's a big deal. Take it or leave it. Should this bill become law, do you know what we'll done? Thrown 16 million Americans off health insurance and closed many vulnerable small hospitals, all to pay for tax breaks for millionaires and billionaires. Maybe some of my Republicans are okay with that. I don't think the American people are. I'm hoping that sanity and common sense prevail. We need 4. We need 4 senators to step up and say, stop this train. We've got to sit down and do our homework. We cannot expose the American families and the American economy to do this in the name of preserving tax breaks for the wealthiest people. Elon Musk seems to be doing okay in life, right? The wealthiest man in the world. Do you know what the tax break is for Elon Musk on the bill that's before us on the floor? $346,000, a lot of money. To him, he won't even notice it. Giving him a tax break, he won't notice, and taking away health insurance from families who will be devastated, 16 million around the country. It's an important choice, and it's one we should make the right one. I yield the floor.
Mr. President.
I recognize a senator from Kentucky.
In deciding whether to vote for the big, not-so-beautiful bill, I've asked a very specific question. Will the deficit be more or less next year? The answer, without question, is this bill will grow the deficit. The federal government has fancy formulas and hundreds of wonky accountants who inform us of their projections over 10 years. But you often can't trust these projections. In an excellent piece written by the Foundation for Economics and Education entitled "The CBO's Projections Are Worse Than Useless," Eric Schuler writes, "Long-term analysis and language is commonplace in U.S. national politics, but it achieves no useful outcome. It confuses far more than it clarifies. It does not provide accurate estimates of long-term results. It does not improve the average voter's understanding of policy effects. And it gives politicians a means to claim they are being fiscally responsible without actually exercising any prudence whatsoever. Sometimes the predictions are off because a new Congress is elected and changes the law. Eric Schuler writes that for any projection of a 10-year budget to be accurate, the Congressional Budget Office has to assume that the law won't change for 10 years, even as most of the politicians that make the laws risk being replaced every 2 years, and all of them advocate for changes of one stripe or another. Schuler states that few in Washington will admit Congress has a knack for starting any proposed cuts in the later years while letting spending run wild in the immediate future. Sometimes these predictions are off by $1 trillion or so because the economy grew more slowly or more quickly than anticipated. Bruce Thompson, a former Senate aide and Assistant Secretary of Treasury, writes, "The Congressional Budget Office miscalculated the deficit last year by $1 trillion. So in deciding whether to vote for any big, monstrous bill, it helps to ask the right question. To me, the most pertinent question is how will the bill affect the deficit in the next year? Currently, our deficit is estimated to be a little under $2 trillion this year. What will happen to the debt in 2026 if this bill passes? Well, using the math most favorable to the supporters of the bill, referred to as the policy baseline, the deficit in 2026 will still be $270 billion more than this year. So even using the math, even using the formulas that the supporters of the bill like, the deficit will grow by $270 billion next year. That's just not good if you profess to be fiscally conservative. Why will the deficit grow next year? Well, even if you argue that the 2017 tax cuts don't need to be counted in the calculation at all, the new tax cuts add up to $234 billion to the debt next year. In addition, the big not-so-beautiful bill adds new spending of over $500 billion, military, border, agricultural subsidies, etc. That spending is front-loaded and will be spent in the first 4 years of the 10-year window. Legislated spending is one of the few items in the bill that is exact. It isn't estimated. If they say they'll spend $500 billion, they're going to spend $500 billion, all in the first few years. So in order not to add to the deficit, the BBB, the big not-so-beautiful bill, has to have spending cuts to counter all the new spending. Unfortunately, the spending cuts are backloaded to the final 5 years of the 10-year window when several tax cuts expire and the spending increases are finished. In addition, elections occur every 2 years and could easily wipe out any perceived savings that might occur in the later year. Republicans have not liked. This is the projection they are using, says the debt will add $500 billion in the first 5 years. Now, they say somehow, miraculously, in the last 5 years, it gets to a $500 billion in savings. So it's $1 trillion shift from year 5 to year 10. The CBO scores it differently, not as encouraging, and says it adds over $3 trillion in debt. So which is it? Does this bill save $500 billion over 10, or does it add $3 trillion over 10? The truth is that anybody, that even a person with a magic crystal ball, it's anybody's guess. Which brings us back to maybe we have to judge the effects of the big, not-so-beautiful bill by looking at what happens to the debt next year. Supporters of the bill admit it adds $270 billion to the debt next year. That's the only thing we know for certain. We don't know what happens in year 3, 4, 7, 8, 9, 10, but we know next year this bill will grow the deficit by $270 billion. In addition, the bill increases the debt ceiling by $5 trillion. What does that mean? That is an admission that they know they aren't controlling the deficit. They know that the ensuing years will add trillions more. So we're adding $2 trillion this year, but they're anticipating, the authors of the bill anticipating, adding more than $2 trillion next year. That doesn't sound at all conservative to me, and that's why I'm a no.
Mr. President.
I recognize the senator from Oregon.
Mr. President, joining me on the floor are experts in the budget process, former chairs and ranking members, Senator Murray, who's been Senate Budget Chair from 2013 through 15, Senator Whitehouse, who's Senate Budget Chair 2023 through 2025, Senator Van Hollen, who was the ranking Democrat on the House Budget Committee in 2011 through 2017. We're here to address a fundamental violation of the law, of Law 313, Section 313, and it is the set of rules for reconciliation. To try to summarize this in the simplest words possible, 100 senators voted to have a special fast-track, filibuster-free pathway solely for reducing the debt. First principle was no deficits could be created in a 10-year period. My Republican colleagues blew that up in 1996 when they wanted to do a tax bill that would create massive deficits. Then, a second pillar was no deficits in any title of the bill in any year after the first 10 years. This bill right now, if this passes, that blows that up. And the third was use honest numbers, Congressional Budget Office numbers. I have a letter here from the Congressional Budget Office, and they say, the estimate is relative to CBO's January 2025 baseline. CBO is required to construct its baseline under the assumptions specified in the Balanced Budget and Emergency Deficit Control Act and the Congressional Budget and Impoundment Act. In response to your questions about the cost of Title VII, the question was, would Title VII increase the deficit by more than the $1.5 trillion over the 2025 through 34 period? The answer is yes. CBO estimates that enacting would increase the deficit by nearly $3.5 trillion over the 2025-2034 period, $3.5 trillion. We then asked, would it increase deficits in the years beyond 2034, beyond the 10-year window? The answer was yes. But if you ask my Republican friends, they say, no, no, no. We're inventing a new theory, and that is that anything that the 2017 tax giveaway to the billionaires put into the law that expired after 10 years, we're just going to assume it would have continued, and therefore, us continuing it doesn't cost anything. That's a pretty crazy notion, that if they didn't put it into the bill, the law says it ends, but they say, no, no, it would have continued anyway through some magical way. So therefore, a tax break for the really wealthy costs nothing. This is exactly the type of lying to ourselves, smoke and mirrors that 100 senators agreed to end back in 1974. And that it has continued, that piece of it has continued in place for 51 years until this moment in this Senate by this Republican majority says we're going to start lying to ourselves and lying to the American people about what this bill costs. But we're not going to lie. We're going to tell you the truth. This bill costs well over $3 trillion over 10 years and some $30+ trillion on top of existing deficits and debt because of the provisions that are in this particular bill. Our current debt, national debt, that's been run up since the Declaration of Independence is around $36.5 trillion. This bill basically matches that in creating that much additional debt over the next 30 years. This is a huge assault on the programs that we can sustain as a nation for the people of America. People struggling to get on their feet, so we want affordable housing programs. We want to have fair and quality health care. We want to have an education system that gives every child the opportunity to thrive. We want to create a robust economy through investment so there are good jobs, because no government program is better than a good job. All those imperiled by this bill because the Republican leadership is lying to the American people and lying to ourselves. So we're here to tell the truth, and first of all, we're going to turn to Senator Murray, who, as I mentioned, was the Senate Budget Chair from 2013 to 2015.
Mr. President.
I recognize the senator from Washington State.
I thank the senator from Oregon and our other budget chairs, ranking members from previous years, because this is really important. Mr. President, there are some things you can't change with legislation, despite what my colleagues on the other side of the aisle seem to believe. For example, 1 + 1 is 2. And while $1 trillion might have a lot of zeros in it, it is, in fact, a much, much bigger number. Now, that might sound obvious, but apparently my colleagues across the aisle need a little reminder, because right now, Republicans are pretending not to get it. It is almost beyond belief, and it is certainly beyond common sense. After years of complaining about the debt, in fact, at the same time they're talking about how we need to address the debt, Republicans now are suddenly pretending they don't know how to count. Republicans are suddenly pretending the parliamentarian doesn't exist if they don't talk to her. Republicans are suddenly pretending that precedent doesn't exist if they just fake amnesia, and that norms and consequences for breaking them will just disappear if they wish it away really hard. My preschool students had more common sense. Republicans should know if they replace math with magic, if they tear up the Senate process, if they blow off the Senate parliamentarian, that bill will come due. And not just the bill for $4 trillion blown on tax cuts for billionaires and corporations, the bill will also come due for trashing this Senate process and precedent when Republicans are no longer in the majority. Mr. President, if Republicans are serious about plowing forward with rewriting or ignoring Senate procedure and the laws of mathematics, I just ask, spare me the empty excuses. Spare me the explanations that totally ignore the reality of what you are doing. I mean, do they really think it washes away everything to say, oh, it's fine to break the process in half because we say it's fine? Oh, it's fine. We have the authority to ignore math. Give me a break. To every Republican